Test, 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 test. Okay.
Sit on bed.
Yeah, no, well, choose your words carefully. All right, so just, you know, in front of your mouth, so it should be good. If the volume needs to be adjusted, I'll do it over there, but they all live right now, okay? Okay.
It's funny. You guys have to get out early, right? Yep. Good. I know. That's what he said. I'm sure it's not 12:30. Better check that schedule. They eat at the table. Oh, Chris said you guys had to leave early. And I cheered.
Citrus, solves the problem. Citrus solved the problem. Scurvy?
Scurvy. Really?
Yeah, scurvy.
Solves scurvy?
Yeah, that's why citrus is a big thing for sale. So the corona fucking solves the, line in the corona. Solves the coronavirus. We solve world problems.
Yes, we do. It's right here. This
This is how things get done.
exactly.
All right. You wanted to interview the presiding officer, right?
Did I?
If not, I can.
Sorry about what you're doing.
He wants it.
Doing Mike.
Hold on. I'm coming. They won't come.
Going 6,400 on this one. Huh? Well, this one is a 3 and this one is a 4.
Yeah, I still have it at 3, but I think I'm going to get rid. I want to sell it when I get more money.
Make sure I get this shot. You can find it as a second camera, obviously.
Yeah, there's a second body, and I still have a 1DX.
Yeah.
1DX.
So he's the presiding officer. Yeah. All right, you got it.
Yeah.
caught in there. Let's see. Number of benchmarks that they want us to track. I don't know. You guys get it.
No, and I know what we've seen so far is wrong. I'll tell you a couple reasons why it's unreliable data. There's a couple reasons. One, you're going to have 48 hours and not tracking at the same rate. They don't count as a warrant issue or whatever, so you're not going to see apples to apples. And the second thing is the first 20 days of January, when there was the this 20 days of data right there, was supposed to phase that in. So really we talk about benchmarks in January, it's part of the January 20 on it. So,
No, but as far as track, I don't track. I know they just.
I'll text you him. I'll text you his number. Yep. All right. Well, I know Bill. Is he? Yeah, he said he was. His wife is. Yeah, it's gonna be a last minute decision. Text me if you want. I will. All good then? Thank you. No problem. Thank you guys. Where's I know she's supposed to the hearing itself. I would be a fool to say what time. To guess the time. I just could go for hours. We know who you are. I wouldn't worry too much.
Jump yet.
I don't care what people think of me in regard to this issue. This family woman, so we can see. I'll see what I have to say. Trust me. Like deceiving, that's all I have to say, deceiving. So, and I'm getting, it's so funny, like people like writing.
I would like to invite all of the legislators to the chambers so that we can begin our hearing.
God bless the two.
Okay, ladies and gentlemen, I'd like to get started. So to begin today's hearing, I'm going to ask Legislator Bill Gaylord to lead us in the Pledge of Allegiance.
All right, if everyone would please rise, face the flag of our great nation. Join me by saying, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you very much for attending today's hearing on the criminal justice reform and its effects on Nassau County and our residents. We would like to get to our speakers as quickly as possible, so I will offer just a few brief remarks. It has been apparent for months that criminal justice reform would have significant effects on our county, on our law enforcement, on our residents. Most of us did not realize that the effects and impacts would be as immediate and as severe. Now, everyone agrees that low-level offenders who pose no risk to the community and who do not have the means to pay jail should not languish in jail. That is simple justice, and everyone supports that reform. However, the criminal justice reform goes much farther than simple reform. It has drastically changed law enforcement in the county and has taken away the discretion of judges to assign bail to the vast majority of crimes. Over the last month or so, we have seen drug dealers caught with massive amounts of fentanyl and other illegal substances being immediately released. We have seen bank robbers who are repeat offenders being released, home invaders being released, repeat DWI offenders being immediately released, and the list goes on. Cashless bail and the new discovery rules place enormous burdens on our county, on our law enforcement professionals, on our district attorney. We need to know more about what they are doing and how they are handling and how they are planning to handle the effects of this criminal justice reform. We also need to hear from the representatives of our law enforcement, the actual men and women who keep this county safe. And we need to hear from the public. Now, we know from the newspapers that there are discussions and proposals in Albany to revise the criminal justice reform, to change it, to do away with some of the more negative impacts. And one of the purposes of this hearing is to keep the focus on this issue, to give momentum to those in Albany who seek to change the criminal justice reform. So having said that, I would like to offer to Minority Leader Abrahams the opportunity to say a few words.
Thank you, Presiding Officer. First and foremost, I think everyone on this dais agrees that there needs to be some level of reforms. I think when the announcement of the provisions in the bail reform came out, our caucus reached out to those in the state that were actually a part of the enactment of this law and expressed our concerns. However, today's hearing is built on what we believe is a farce. By no doubt and by no stretch of the imagination, we believe that there needs to be reforms. But on December 16th, the Republican majority decided to call on the county executive as if she had some debate, discussion, some enactment, some responsibility with the bail reforms that were passed in the state. And I quote, they called on the county executive to oppose the crime reform law. The county executive, all she did was implement the law. But suddenly she has been thrust into the fire by the majority by insinuating that she had something to do with more than following the law. Furthermore, let's be clear. By passing the bail reforms that occurred in the state, the Republicans are politicking and fear-mongering more than anything else. Let's stay in our lane. The bottom line is we should be expressing our concerns, and I would have taken a little less exception if they expressed their concerns to their state representatives. However, they've taken the tack to try to loop in the county officials that are a part of this. Now, we should hear from our police commissioner on how he's going to deal with the law, and we should hear from our district attorney just the same. But when I saw the story that appeared on December 16th that called on the county executive to denounce, why aren't we calling on denouncing the SALT tax, which was passed by the federal government? Why haven't we called hearings in regards to Newmick? We have no business at all, other than fact gathering at this hearing, than anything else. The bottom line is very simple. We have a responsibility to our public to ensure that we give them fair and balanced information. That's where this begins and that's where this should end. The bottom line is very simple for us. The county did not pass, did not have debates or discussions, did have nothing to do with this enactment of this law. No Democrat, no Republican in this legislature had anything to do with this law. But today we find ourselves holding a hearing basically which starts with the premise of calling on the county executive to denounce the law, which to me is just trying to link her to something that you believe that you gained some type of political advantage on. And that to me is wrong. And that to me ties into everything that is more fear-mongering than anything else. And as I said before, let's be clear. We believe that there needs to be changes to this law. And we believe that we have seen some of those changes that were announced yesterday by the Senate Majority Leader in New York State. However, I just want to say it again and emphatically that the bottom line for us is very simple, that this legislature, by some of its members' actions, have taken irresponsible, reckless actions by trying to deceive the public that the county executive or Democrats in a whole are in favor or are supportive of any of the measures of the criminal justice reform bill. We believe, yes, as the presiding officer said, and the one thing I will agree, low-level crimes that folks that are nonviolent should not be languishing in jail for periods of time when they should be able to have some type of fairness and balance and justice that should be applied to them. But today, and violent criminals should have the discretion of judicial review before they proceed or get out of jail. But let's be clear today. Today is all about the Republicans trying to use this issue to further their politics. That's it. If it was more built on fact gathering, if it wasn't built on accusations and insinuations, then they would have restored some more credibility. But the fact remains that that news story that goes back to December 16th was very clear. It called on the county executive, who again had no debate, no discussion to our knowledge, had no enactment, did not vote on any bills, and all she did was try to comply with the bill. But somehow she got tied and linked into it. Thank you.
I'm more than a little bit surprised that there would be any sort of controversy of the fact that we're having this hearing. I would assume that all the legislators would be speaking with one voice on this issue, in fact, in urging all legislators in Albany to change the bill. County executive was called upon in mid-December to implement a plan to deal with criminal justice reform, and she did several days after the press conference. More importantly, the county executive since that time has been consistently calling on the state to remake this law. So she is not the subject of this hearing. I disagree with the minority leader, however, that with the premise that we have nothing to do with respect to criminal justice reform since it was adopted by Albany. It is our police, it is our police officers, men and women, it is our district attorney who have to enforce the laws in this county, who have to deal with this. It is our judges in Nassau County who are being restrained from keeping dangerous suspects off the streets. And it's our residents, ultimately, who are endangered if there is a threat to public safety, as we believe there is. So to argue that there is some reason we should not have this hearing is wrong. As I said, one of the reasons we're doing this is to keep the pressure on Albany. They are feeling the pressure. There are proposals now to change this law, but things that have a way of getting shelved. So we want to make sure that our representatives in Albany continue that momentum, get this changed, reform this law. Having said that, yes, go ahead.
So I disagree with a couple of things the presiding officer just said. One, first and foremost, we agree that there should be a hearing, but not built on the premise of denouncing the county executive.
Where did you see us?
Presiding officer, I did not cut you off
Sure.
when you spoke.
Sure. Go ahead.
And your actions that were presented in the December 16th story, and I could quote you and quote Mr. Ferretti just the same, but I didn't want to go down that road. Your story talked about denouncing, asking the county executive to denounce, as well as the 6 Democrats in the state Senate that represent Long Island. You were calling on them to denounce the bail reform bill. That's almost like me saying to you that we should call on our members of Congress that happen to be Republicans to denounce the SALT tax. That is, and then furthermore, to hold hearings on it. So from that standpoint, I am in support. We have indicated we are in support of the police department providing data to this body to ensure that we are making the public safe. But your premise from day one on this bill has been politics. And you may have some good points in regards to serving the public. That part we don't disagree with, and that's why we're here today. However, it's been clouded by politics and fear-mongering more than anything else. Furthermore, I'll say this. The bottom line is, if we're going to start holding hearings on items that do not originate from this body, that's all well and good. I would like to hold a hearing on the SALT tax as well, because I see my residents being hurt by thousands of dollars by something that was implemented by a Republican president. So if we want to start doing that kind of stuff, let's go right ahead. Let's hold a hearing on the Nassau University Medical Center. I've been asking for a hearing on that. That actually impacts Nassau County residents just as this does, and has a financial impact on that as well. I've been calling on hearings for that since April of last year. So let's do it. So from that standpoint, I don't see why. I'm not saying you shouldn't have the hearing. I'm saying your premise for building the hearing up until where we are today started with denouncing someone that had no debate, no discussion, no vote, no ability to impact change other than calling on it from a bully pulpit for this particular item that's in front of us today. That's what I'm asking for, is that your premise in that story, to me, resonated of more politics than good government and the best interests of the people of Nassau County.
Well, it's apparent that the minority somehow feels pressure on this issue. But I could say this, who cares what happened in a press conference 2 months ago? The county executive has done the right thing since then. She has repeatedly called on the state legislature to amend this bill. So she has nothing to do with this hearing. This is about exploring what this law is doing to our communities. And so the fact that there was a press conference 2 months ago is completely irrelevant. Let's finally hear from the people.
The point of the press conference.
We're done with the
the
debate.
point-
Let's talk to
Presiding officer, the point of the press
I'm
conference.
going to call the first witness, which is Mr. Victor Maldonado.
So as I said before,
Mr. Victor Maldonado, would you please
Mr.
take the
Presiding
floor?
officer, so you're going to cut off the debate. Look, we
Yeah,
want
it's
to be,
done.
we want to
It's
be,
done.
we
We're
want,
done.
we want to get, we want to get
No,
to the.
we want to hear from the people.
We would like to hear from the people as well, but the
debate
people should
among us
also
is done.
understand that you have.
Would you please let
you
Mr.
have
Maldonado proceed?
Mr. Presiding officer,
Would you please let Mr. Maldonado
you have
proceed?
created this premise, and now you want to take it back.
is
You want to
stunning
hit
to
the
me.
reset button after you called on somebody that had no jurisdiction in the actual bail
you
reform.
please let
That's
Mr.
what you decided
Maldonado
to do.
speak?
That's what you
Would you
decided to do.
please let Mr. Maldonado
so
speak?
as I said before, let's start the
You'd
call
rather
hearings.
speak to Mr. Maldonado,
No,
is that right?
no, that's
Then
not what I'm
stop
saying.
speaking. Would you let the gentleman speak?
But, Mr. Presiding officer,
You're out of order.
You said no. I'm not out of
You're
order.
completely out of
You
order.
made a remark in regards to my statement, and now I'm responding to your remark. I never cut you off, and now you're trying to cut me off, which I don't understand the logic of that. Unless you are understandable, you understand that you made a mistake a month ago
What are
or
you
2 months
talking
ago
about?
when you
Would
actually.
please- it's about a bail reform here.
Okay.
Who cares what press conference existed 2
Yeah,
months ago?
well, the public should care because this is you're using this vehicle after galvanizing politics and the issue.
Why are you concerned about listening to the people, understanding this issue?
No.
You think it's a bad issue for you?
No.
Let's join together and get this changed. That's all we
Well,
want to do.
if we were really sincerely trying to join together, you and I would have written a joint letter, not just to the county executive.
let's
the
write a
county
joint
executive
letter.
would have joined with us. We should have written a joint letter to the state.
I agree with you. Let's do it.
But you're saying that now 2 months after the fact,
Oh,
after
my goodness.
you attacked the county
Who
executive.
cares? It was 2 months
So,
ago.
I know.
She's
I
done
know,
the right
I
thing
know,
since then.
I know.
How many times do I have to say it?
I
She's
get
done
that.
the right
I
thing
get
since
that.
then.
I get that.
All right?
But you've decided that your hearing is based off of a farce premise.
Guys, I think you made your point.
Yeah, I
Thank
think you
you.
did. Let's go. Mr. Maldonado.
Thank you for having me here to speak on bail reform. I wrote a speech. I'm going to follow it verbatim. I'm here to lend a voice to the many of us who innocently and unwittingly have become victims of bail reform and cannot be here today. I'm here to speak out of an egregious law passed in our great state of New York that does not take into consideration the consequences affecting the public safety of its constituents. It is with a broken heart, a broken, heavy heart, that I stand before you to show the reality of what Albany has created. Our reality, our own personal reality, is as horrible as they come. Our reality is not based on sensationalism. It is not based on media hype. It is not based on exaggeration. It is based on fact. The most relevant one is that my son Jonathan Flores Maldonado has lost his life as a direct result of the enactment of this law. Sadly, I am here today because Lillian and I have lost our son. Rebecca has lost her soulmate. Victor, Matthew, Jack, Ashley, and Justin lost a beloved brother. And the community lost a good, caring, law-abiding young man at the beginning of his promising life with a bright future ahead of him. Who was Jonathan Maldonado? Jonathan Flores Maldonado was an intelligent, caring young man who, in the early hours of Sunday morning of January 12, 2020, while driving for Uber and getting people home safely, was killed in a tragic car accident by the accused. He had been working extra shifts on the weekends so he could do something special for Valentine's Day for Rebecca. We believe he was saving money to buy her an engagement ring and propose. It was something I'd been talking about for quite some time. Valentine's Day is tomorrow. And because of this law, we will be grieving the loss of an incredible young man, when we should be celebrating the engagement of one of the most wonderful partnerships I've ever seen. Last May, we got to see Jonathan graduate with a degree in biology from Buffalo State University. Instead of heading back to Long Island, he decided to stay in Buffalo with his beloved Rebecca and support her while she was finishing her school. Jonathan started driving for Uber to make ends meet while also saving for his life together with Rebecca. Together they had plans to move to New York. Close to me in the Bronx, he always gravitated toward family. Jonathan and Rebecca had plans to get married and have 3 children. They even planned a cruise for Rebecca's parents, who are going to be celebrating their 30-year anniversary. We were so excited to officially welcome Rebecca into our family and vice versa. And while we will always be family, things will never be the same without Jonathan. Jonathan was the son who drove 8 hours to go check on his grandparents, then drove another 2 hours to check on his mom, and on his way back to Buffalo, he would come by and see me. Sometimes we'll play 18 holes of golf at Van Cortlandt or 9 at Marshall. We will talk about life, current events, and how to get better at golf. Jonathan would drive his little sister, Ashley, to Baltimore whenever we had a family event. He would drive his little sister to Baltimore before he went to Buffalo. He always cared for everyone. He knew. He always saw the good in people. Jonathan signed up to be an organ donor. He was also a blood donor, and he donated often with the New York Blood Center. They was always asking for Jonathan to come to donate because he had a very high platelet count. Sometimes that's quite rare in a person. He has precious blood, and he donated it to save other people's lives. And then there's the flip side. The man responsible for taking my son's life. The accused is no stranger to the criminal justice system. The accused has been arrested multiple times for DWIs and tampering with an ignition interlock device. He has multiple DWI convictions and multiple felony convictions. He didn't care that he drove intoxicated. He didn't care that he did it often with absolutely no regard for the safety of himself or others, and Jonathan paid the ultimate price. The accused on January 1st, 2020, was arrested and released under new bail reform law for interfering with his ignition interlock device. This device was ordered to prevent this man from drunk driving, as he has done before many times. On January 10th, the accused appeared in court for this charge and was released without bail. Why? I heard it was because he had not been fingerprinted. Really? Multiple felonies, DWI convictions, and you still need his fingerprints. Not even 2 whole days later, the accused got behind the wheel of a car while drunk, 3 times over the legal limit, rear-ended my son at 135 miles per hour, killing him. The police arrived soon enough to see him trying to escape as he fought off the officers. He told them that it didn't even matter because the law changed on January 1st and I will be out tomorrow. Does anybody see anything wrong here? Anybody? Political parties fighting each other while they should be working together to bring justice to my son. The bottom line, nothing has changed. The fact of the matter is all of this could have been prevented. A young life, a good soul, a man that had aspirations to help others by studying biology and pursuing a career in medicine, has been lost. Bail reform has to happen. Bail reform allowed this to happen, excuse me. It is an egregious law, period. No thoughts have gone into this law. Public safety was not considered. A judge's discretion, professional discretion, was left out, and the history of the accused could not be used to make an informed decision. There are many things wrong with this law that need to be amended before more lives are lost and more families are shattered. And so I have a lot of questions. The law emboldens career criminals that will take advantage of us all. How many times can a person commit a crime, be arraigned, and released? Who has decided what is and what is not a violent crime? What of the law enforcement officer's morale, who knows that an arrest will only lead to a release of a person accused of a vicious crime? Why even bother arresting a criminal if the judges can't hold him? Jonathan's death is on the hand of the legislative body who passed the bill into law that gives the judge no discretion. Fingerprinted offenses should apply to any crime where public safety is concerned, including drunk driving or tampering with an ignition interlock device, regardless of what county you live in. Those are violent offenses. They resulted in the loss of my beautiful son. Anytime a drunk person gets behind the wheel of a car, they run the risk of killing someone. It needs to be changed, and it needs to be changed now. The family of victims don't want flowers, don't want condolences, don't want to hear, "I am so sorry for your loss." And they sure as hell don't want their information given out to the defendants. We want justice, and we want to heal. Here are just a few of the crimes where the accused can walk right out of jail and maybe just pay you a visit. Third-degree assault, reckless assault of a child, stalking as a hate crime, vehicular manslaughter, aggravated vehicular slaughter, promoting a suicide attempt, aggravated vehicular manslaughter, third, fourth, and fifth-degree arson, bail jumping, escape, endangering the welfare of a child, promoting a sexual performance by a child, criminal possession of a firearm, criminal possession of a weapon on school grounds, obstruction government services with a bomb. If you're a victim or a witness to any of these crimes I just mentioned, guess what? The accused will have your information. Let's look at the criminal and what it's like on the inside of the criminal justice system. Career criminals don't stop once they're on the inside. And when they're released, where do they think they will look for their next victims and where their victims will be living? In the same communities that they live or are released to. That's where. Albany, you are not doing anyone any favors by treating this very complicated situation with a sledgehammer. This law has to be changed so that it applies to the right people. People who for the first time have made a mistake, have shown remorse, and an effort to rehabilitate. People who have a loving family and need to work to support others and give love. People make mistakes, but career criminals don't make mistakes. And they are going to take this law and turn it into their advantage by committing more crimes with the knowledge that they will be released. These people or career criminals are being given event tickets and gift cards as incentives for showing up to their court hearings. We are awarding the criminals that just robbed your grandmother, burglarized your home, sold your child into prostitution, kidnapped your daughter, or sold drugs to your child that resulted in their death. This law should not apply to these criminals. Repeat offenders and career criminals who have no regard for humanity or human decency. Any judge would have seen that, but that doesn't matter with this new law. So much has gone wrong, and all of it could have been prevented by taking into consideration 5 things. Public safety. history, or pattern of the accused. Alternative solutions such as rehabs, halfway houses for people in need of rehabilitation and or housing. Recommendation of law enforcement and criminal corrections personnel who have first-hand knowledge of the person being released. And most importantly, the judge's discretion. In closing, our family appreciates that all of you have done, are advocating. We are very grateful. I would like to thank all of the legislators, law enforcement, and judicial personnel who are fighting to get this law amended. I also want to thank the media and the investigative reporters who have covered this tragic event and other tragic events related to this egregious law. We have a lot of work to do, and we must not give up. We must bring justice to Jonathan. Jonathan, I believe that you are in the loving grace of Almighty God. We miss you so very much. All. Our hearts are broken, but I will take comfort in knowing that your death will not go in vain. Our lives will change forever because of the person you were and what you meant to all of us. I will fight to get this law amended so that the people who deserve it and want a second chance will have one, and so that career criminals and repeat offenders do not. I just want to say to you that your family and friends love you. We miss you so very much, and you will never, ever be forgotten. See you in heaven. Save me at tea time. We love you. Thank you, everyone, and may God bless us all.
Mr. Maldonado, all of us up here are parents, and all of us up here feel that our hearts go out to you and your family in this time, and I cannot imagine how much courage it took to do that, and as you said, we all will be advocating that this law be changed to prevent a tragedy like this from happening going forward. Does anyone else want to say anything?
Mr. Maldonado, I don't know if he had left or he's sitting down. I can't see him behind the cameras. I'm sorry. But again, just to reiterate what the presiding officer had indicated, I know there's no words that I can express on behalf of this caucus or myself that would give you your family the comfort that it needs at this time. We pray that with God's help, you'll be able to find your way through this very difficult situation. And as you said before, we will find justice for your son as well as all of those that have been hurt over the last several weeks in regards to getting changes to the bail reform bill.
Would anyone else like to add anything? Sure, Legislator Ford.
Mr. Maldonado, also my condolences. Nothing is worse than the loss of a child, and to lose your son in such a way, it just is so heartbreaking. And I applaud your courage to be able to come here and speak about this and, to fight for what needs to be done and to restore justice back into our system. So please extend our condolences to your family, to all of you. I don't know what to say, but God bless you.
Legislator Rhodes.
Thank you, Mr. Presiding Officer. Mr. Maldonado, I just want to say thank you. I want to say thank you for your courage in coming forward and doing honor to your son. The situation that your family is involved in and what happened to Jonathan is an absolute tragedy. And the fact that you're coming forward provides an opportunity for all of us to turn the tragedy of your son's story into a cause for good, into an opportunity to be able to correct an injustice that was done through criminal justice reform and particularly through cashless bail. And I can't applaud your courage enough for taking an unimaginable tragedy and turning it into an opportunity, hopefully, to do good for others by pushing for repeal and for sensible amendments to this bill. So I just want to say thank you for taking the time for coming down and for sharing your story with all of us.
Okay. All right, so we have two speakers who would like to make a presentation at this time. Our Commissioner of Police, Patrick Ryder, and Assistant District Attorney, Jed Painter. Gentlemen.
Kind of loss of words right now after hearing Mr. Maldonado speak, and our prayers are with him and his family. And the earlier exchange here on the floor shows the passion of everybody involved. Everybody involved wants to see change. There are two victims here. There are victims that are victimized again because of the change, how extreme that it has been. And then are the victims of the kids that are sitting in jail because they can't afford bail and because they don't have an income to get them out and get a better attorney. So I have been called that I am politicizing the issue. I'm not politicizing the issue. I don't have an agenda except for this. I speak for the victims that can't speak for themselves. I fight for the victims that can't fight for themselves. We take an oath in law enforcement to protect and serve the people, all the people, no matter what race, no matter what religion, or no matter what side of the law they're on. We always treat them with respect, and we treat them with professionalism, and that's what our police department wants to continue to do. I will speak with the data, I will give you the truth, I will give you the facts, and then you make your own interpretation. I said that last week, and it came around against me, but we live in the safest county for its size in the country. The crime has never been so low. We're down 30% in crime. Our overdoses are trending in the right direction. Our homicides have been record lows. Our robberies and burglaries have extremely dropped over the last several years. Now, I'll give you some crime numbers, but I want to make a point to that. It's too small of a data set to really jump one way or the other. It's only been 40-something days. And to the credit of Jack Maple, the creator of CompStat will tell you that crime is affected in the short term by weather. We've had a very mild winter. So I can't make a direct link to anything at this point regarding crime, except for that I did say early, and I'll say it again, that quality of life crimes do increase when there is no, and I don't want to use the word penalty, but some kind of answer to someone that breaks the law and how we can help them. Whether it's putting them in the right court, putting them into recovery, or putting them into jail. All of that process and the points of which we'll bring up today. But if you look at our crime numbers, all of our violent crime is actually down. Our robbery commercials are down 13 from 20 last year. Our street robberies are down 24 from 30. But our assaults, they went up 52 over 34. Our residential burglaries went up 48 over 33. And our commercial burglaries went up 42 over 36. Major crime is up 6.5%, but again, I will emphasize the data set is too small to make that comparison yet. But our total crime number, which includes those small level crimes, has gone up 5%. We were asked to form a committee to look at how justice reform will affect us here in Nassau County. The report was completed today. It will be sent to all of you here in the legislature, both the majority and the minority, and it will be also sent to the committee members that sent me all of their ideas and presentations. But as I read through it, I will tell you that many of them are addressed today in Newsday. And again, that's what's being proposed. How it comes out, I don't know. But Albany has been listening. Albany has been looking to make those changes. The issues presented, the new legislation limits the cases of qualifying offenses for which a judge has the option to set cash bail. Our recommendation is that you do not limit the ability to set cash bail based on the crime charged. Again, I believe that's being addressed according to the Newsday article. Issues presented. The new legislation has limited the factors of which the court can consider determining the defendant's custody status pending trial. We've seen cases where they've walked out. We've seen our recent robbery subject, which was arrested for a bank robbery, was given the ankle bracelet. We gave the controls. He cut the ankle bracelet off. He committed 2 more bank robberies. He has now been remanded as he was arrested the other night. Ramifications for violating non-monetary bail conditions, such as electronic monitoring, are not significant enough to deter defendant from violating these terms. Many people will fit into electronic monitoring, but not all will fit into electronic monitoring. Many should be released without bail, but not all should be released without bail. The issue presented, pursuant to the new legislation, the court cannot immediately issue a bench warrant. We've taken the control out of our judge's hands to determine, depending on that background of that individual, that history of that individual, if he should immediately issue that bench warrant, so that we can go out as law enforcement and execute that warrant. The new legislation limits judicial discretion when considering applications before the court. Again, a judge should have and always has the opportunity to see that person's past history. There are many kids that sit in jail, first-time offenders, for a low-level drug charge that shouldn't be there because they couldn't afford bail or they didn't have the right attorney. I agree with that, and I agree with that part of justice reform. But there are many people that are arrested, again, for small or even larger drug cases that are now going to get out because of justice reform. We need to look at that. We need to look at the history and the circumstances behind it. What put us there? What put that child there? What put that kid there or that man there or woman there, that we can then make the right decision? Again, that's why we have a justice system in place. Issue presented, pursuant to the new legislation, the district attorney cannot enter into a plea bargain until discovery has been produced. I'm going to let District Attorney Jed Painter speak on that. Issue presented, the discovery reform also includes provisions that witnesses must provide their names and addresses. This is the one that is close and dear to me. Our victim that did get brutally beaten and killed by MS-13 in the Newcastle area. I went to the wake. I spoke to his sister. I met the family. It's a horrible, horrible crime that no one should go through. And the people in Westbury deserve better. That witness deserved better. I never said there was a direct link. Never said there was a direct link to justice reform. I just gave the facts, and I left the interpretation up to the people. And again, I'll say, I don't know there is a direct link. Our homicide guys have been working day and night to make that arrest and make sure that they answer, because he was a hero, this man. He stood up against MS-13. He's willing to testify against MS-13, and he died at the hands of MS-13. And I said, and I'll say it again, we as all of us, need to do more for our victims, all of our victims. That 16-year-old that sits in jail for marijuana that shouldn't be there, and the victims that have been brutalized and beaten and threatened by MS-13 or any other person in this county. So as the police department, we've been asked to start to tally the data, which we have most of this data, and we'll continue to collect that data. Some of that data in the new proposed law is given to us. We'll have to get from the courts, and we'll work with the district attorneys to provide it. The data will speak for itself, and hopefully it speaks for our victims. Thank you.
Legislator Ford. I guess we'll have some questions for the Commissioner, then we'll go to your presentation, okay?
Good morning, sir. I think it's a sad state that you have to sit here after you testify in regard to this bail reform legislation to explain yourself after the murder of somebody who was in, that witnessed something and was going to be a witness toward the MS-13, to explain your remarks, that may have been said in the spirit of being hurt by this murder, this senseless murder of an innocent person, that you have to defend, perhaps the way that maybe people interpreted it. I think you are an excellent police commissioner. You're a great leader. And I think you have every right to say what you have to say without any fear of retribution or anybody coming out against you. And I applaud you for your courage, because I think all too often, and I'm tired. I'm tired of political rhetoric with all of this. When we look at this and we all say, well, they're politicizing this whole thing because it's maybe the Republicans. I heard it early in December when all of a sudden this started, coming out as to what was going to happen to our communities here in and our neighborhoods here in New York State. That what may happen to people that are witnesses, people that can be victimized. And more importantly to me as well, we always forget about our police officers, our officers, that their morale is being challenged, that when they turn around and they go to arrest somebody and they realize they're only going to go inside and wash their hands and the person's already out walking the street committing another crime. When we see that people have no fear of attacking police officers, even go into a precinct to shoot them up, I think this is a disgrace. But I urge you to keep it up, to make sure that you speak what you have to say, because you are our law and order here in Nassau County, and I appreciate the hard work that you do for all of us. But I would like to know something, because I know that we say, well, why didn't we all get together and maybe write letters and reach out to the Democrats in the Senate in New York State? Before they took that vote last year, did they reach out to you? Did they reach out to all the police commissioners throughout New York State and ask them what impact this legislation will have on your ability to do your job, to make sure to keep our communities safe, and to make sure that our police officers are protected as well?
I can't speak for everybody in the state, but I can speak for myself. I was not conferred at all on this issue.
So they made this change, this progressive change, and we all understand. And I think that you are right, Kavan, when we talk about having open discussions. Let's talk about things more often. But when we look at this, we all know that the justice system needed reform. We all know that our legal aid lawyers, who are the ones that represent the people that are indigent, that can't afford high-priced attorneys, that can't afford to have any bail, that these legal aid lawyers are underpaid and they're overworked. They have too many cases. They can't probably always maybe defend these low-level crimes. So a lot of times probably they may end up having them to turn around and maybe plead out, maybe do 2 or 3 days in jail, when these people should not be in jail. Prior to this vote, maybe at that point, they should have brought all of us in to talk about this and say to ourselves, to say to everybody, what do we need to do? Because it is unfair. It breaks my heart when I have parents that called me up because their children were in Nassau County Jail and they were worried about their medication, were they getting fed, and the kids really weren't bad criminals, but this is what happens. The discussion should have taken place last year. Now we have poor Mr. Maldonado, who had to bury his son too soon. We have families that are living in fear that because there are criminals walking out amongst us, because of this disastrous and ill-conceived legislation on the part of the senators and the assembly people in the New York State government. And I think that this in itself is a crime against the people, the good people here in Nassau County and New York State. I think that we all have to stand up, and it doesn't mean just because it's not just Republicans that are fighting against this. I happen to be a Democrat, and I'm proud to be in this party. But I am damn tired of what is going on when I look at this, and I have to worry when you can turn around and dismiss it, that because you feel bad that some of these Republicans came out and spoke, maybe asking Laura Curran to join them. But I find that Laura Curran to be a capable and good leader here in Nassau County. I respect her as our county executive, and I think that she's a strong, independent, strong-willed woman that could stand up to any criticism and to be able to speak her mind on the issues that she feels is important to her without any fear or retribution from anybody else, whether or not it's in New York State or the government. But I think all of us, we should be allowed to say what we have to say. And to me, I'm very emotional. I'm sorry about this, but I happen to be, when I have family that are in the New York City Police Department, when I look at our officers patrolling each and every single day, and we have to worry about this, when we allow people, this gang, to go through the subways, to break up equipment, to be able to call upon, to go against the police, I think that this is terrible. And I think this anarchy has to stop. And I think that all of us must join together to bring common sense legislation back into New York State. And let's start taking this state back so all of us will want to stay, want to live here, and be able to live here. Thank you. And I'm sorry.
Denise. Commissioner, I just want to echo something that Denise just said. You do speak your mind, and it's refreshing, and it's what you should do as the chief law enforcement officer in this county. And we've had individuals who were closer to politicians in the past, and I would much rather have somebody who speaks his mind, as you do. We may like what you say this week, and next week we're not going to like it, but it doesn't really matter. You're just speaking what it is that's important to public safety and to the men and women that you represent. Just in terms of what changes are you making to the police department, as a result of the criminal justice reform?
So the biggest lift for us, obviously going back and reinvestigating cases that someone's been arrested for makes it harder. More time and boots on the ground, which we had a lot of boots on the ground the other day to arrest the individual for the bank robbery. But the biggest haul, and you'll hear from ADA Painter, is the discovery. The amount of people that I have now doing discovery, and what people have to realize, it's retroactive. There's cases that are ongoing from 19 and 18 that we still got to turn over blotters and finding memo books of cops that are retired and that we can't go forward until that information is there. So I have all of my analytical people that normally do analysis so I can get ahead of the patterns and do predictive analysis on crime fighting are now doing discovery. They're all pulling data, pulling videos, pulling GPS data, 911 calls, CB transmissions back and forth. It's a lot of work that we didn't even realize would ever have to be turned over, and now it is. So the resources that we're expending from both, and our court overtime has increased, our overtime for processing has increased, but it's work that we will do. That's what we're paid to do. We'll be professional. It will increase my budget at the end of the year, and we'll get it done as best as we can. We do sometimes, and there's going to be a failure going forward because it's almost impossible to keep up with discovery in a 15 to 30-day period.
Now, you mentioned you've had to shift resources from the area of predictive analysis into complying with discovery responses. Is that accurate?
That is correct.
And our police and our DA or law enforcement have had tremendous success here in Nassau County in reducing the crime rate. Is that in part because you've had resources to put into the predictive analysis to anticipate where the crimes are going to be?
Our success since 2010 has been the fact that we built our Intel Center and we do things like predictive analysis, intelligence-led policing. And again, I'm not going to throw it all at the wall right now because, yes, crime has gone up, but we have a mild winter. We had a mild winter last year also. So, again, I'm factoring all that in. The data set is too short to make that determination. I think the quarterly report will tell you more. We are now starting to catch up on some of the older cases, and that will now start to move some resources back to doing our intel-led policing model and predictive analysis.
Okay. All right. But that is a concern to the extent that you're taking resources away from something that's had such success in order to make sure that I think the onerous discovery requirements are met. So, anyone else have any questions for the Commission? Legislator Ferretti?
Good afternoon, Commissioner.
Good afternoon.
And thank you for your testimony, and thank you for your continued leadership on this issue. I want to speak a little bit about the DMV database. Is it true that New York State required the county to agree in writing not to share information from the DMV database with the federal police or federal agencies?
That was part of an agreement that we had signed recently so that we can continue to access data through the DMV system.
So is it true then that if we didn't sign that agreement, we would not be able to access that data?
That was the way the agreement was written. That is correct.
Now, if we didn't agree to that, and maybe this is a question for Jed or somebody else, but is it legal for New York State to lock us out of that database, that information?
I can't answer that. I'm not an attorney.
Did we at any point, we being the county, consider a lawsuit to compel access if we were not to sign that?
That would be a conversation for the administration.
How is this type of information contained in the database?
The information for normal DMV is entered into a database, and if we need to run on a car stop an individual or his license plate, it would go through that database.
And we did sign the agreement, right?
That is correct.
And so what federal agencies are we prohibited from sharing the information with?
It directly referred to HSI, if I remember correctly.
Okay. And what reasons would a federal agency need to access the database?
I'm sure the concern was that we are not turning over data to HSI to go after those that are undocumented.
Okay. Does the Nassau County Police Department work with these agencies regularly?
We work with all our federal partners.
In what capacity?
Most of them in money laundering cases, most of them in human trafficking, prostitution, white-collar crimes.
Okay, and the ban on sharing this information, are there any exceptions to that ban, or is it carte blanche ban?
I don't have that bill in front of me, and I'm not...
Any that you're aware of?
None that I'm aware of. I did believe it was just with the HSI.
Now, my understanding is that federal law enforcement officials have indicated that this ban puts public and federal law enforcement officials at risk. Do you agree with that?
The data that's coming from the system, providing the information of the person that has in front of me, I have. The data not being shared with HSI, I can't say if it puts them at risk. Their process of going after those that are undocumented is an HSI issue that we don't work with them on. We just focus on the other crimes that we do work with them on.
Well, in the past, has the information that we're now not providing led to investigations into terrorism, sex trafficking, any drug smuggling?
Well, if I may, I believe my guys that still work in the task force have the access to that data, but are prohibited to share it if they're going to be used for immigration purposes. We still do share and use it when we are looking at money laundering, counterterrorism type investigations.
So we still share that type of information?
When we have a money laundering and specific investigation like that, yes, but as a blanket sharing and running names for immigration, we do not do.
Okay. What if that type of investigation involves someone who's here illegally? Do you share that information?
You know what, I honestly can't answer that question. I don't have that document in front of me, exactly what was restricted from it or not.
Well, in the past, would we share that kind of information?
Yes, yes,
Okay.
we would.
And today, you can't say that we still do?
If it was for a counterterrorism investigation and the person happens to be undocumented, of course we would share that.
In the past?
In the past.
But in terms of
we would
today?
still share that and do that investigation with our federal partners. It doesn't matter what the status is. If the criminal activity is there, we would still work with them, and willingly so.
Okay, thank you.
Anyone else have questions? Let's Galo.
Sure, a couple of questions. Thank you, Commissioner, for your presentation, your honesty, and the work that you do to make the county a better and safer place to live, work, and play. And special thanks to all of the officers and law enforcement for what they do as well. You know, I sit on the village, town, city committee as well, and there hasn't been much discussion on the additional workload maybe that the county police department is experiencing, having to work with the villages. Many times, although the villages might have their own police departments, the county takes the lead on many of the more significant crimes, the crimes involving guns and drugs, and threatens society as a whole come under the county's purview. So my questions, the next few questions, are directed at the interaction between the village or city police departments and the county. So what level of coordination does the department have with the village and city police departments to ensure that we are complying with these new criminal justice reforms?
Any assistance that the village uses, if they use our P1 system, that's our case management system, if they use that system to process their arrest, that is all generated and sent to the district attorney's office through ECAP. If it has to do with bail, or I should say not bail, but if it has to do with evidence and so forth, we will assist them on it. So we have always worked with our 18 villages and 2 cities. They are all struggling with the discovery issue. Not so much the processing part, but the fact of what has to be turned over. But villages, for the most part, outside of the larger ones of Freeport, Hempstead, Glen Cove, Rockville Center, their arrest is not as high level. We average 50 arrests a day here in Nassau County. That's 50 people that we have to turn over that data, and some of our bigger villages do have that many, but some of them are more up to date with their technology and has been able, and because they're a smaller village, and able to process that quicker.
So my understanding is the district attorney, and Mr. Painter might have to jump in on this one, even though he hasn't presented yet, but there are certain guidelines. Within 24 hours, there has to be initial turnover of records and whatnot to the district attorney's office, to their early case assessment bureau. Then within, 5 days, and then again at 10 days, and then again every 24 hours thereafter if a new record is created. So is the Nassau County Police Department charged with ensuring the villages meet those timelines, or are they on a direct, coordination link with the district attorney and directly?
I can speak to that. I'm sitting next to a great police commissioner, but I've had to deal with a lot of different police leadership. We have 25 local law enforcement agencies. We got the NYPD. We have Suffolk we've dealt with. We have the New York State Troopers we've dealt with. So we are building relationships with each and every single one, and working on discovery exchange protocols with each and every single one. I'll cover some of that in my presentation.
Okay, all right, well then we'll hold off and wait for that. You mentioned that you share a platform, a computer platform with the villages, or is that something we provide to them, or is it it's a standard piece of equipment every police department purchases into to provide this kind of information to the district attorney's office?
That is the record management system used by the police department in Nassau County. Many of the villages do opt in to take a license from us. We pay for that license through the headquarters tax.
Okay, all right. And do you see any issues that are developing because of these new reform laws between the villages, the town, cities, and our police department?
The biggest issue is that the coordination effort that, look, we've always worked together when a crime scene occurs and we jump in, everybody does their part. But when it comes to gathering data, because we all have different data sets and different ways that we collect data, that's a problem. We've ventured into a software company that has been approved by the legislature moving forward called NICE, and we're hoping that NICE can help alleviate some of these problems and coordinate, sitting like a spider with many different legs, reaching out and pulling that data up to where it needs to be.
Okay, very good. And you mentioned the quarterly report that that was the one where the legislature asked for some information on a quarterly basis. Will we be tracking crimes committed by people who are released with no bail and then recommit crimes? Is that part of the data you'll be collecting?
That is one of the data sets here that we will have to collect, correct.
Thank you. I have no further questions. Thank you, Presiding Officer.
Good. I think the minority leader had questions.
Actually, just to piggyback on Legislator Gaylor's question, that's where more of my questions are tied to. And then I wanted to talk a little bit about the contract the legislature passed in regards to helping with the discovery and the software. And you could talk a little bit, elaborate a little bit more on how you're finding that working, or has it been implemented or implemented fully. But Commissioner, really just wanted to dive into the merits of the bill and your ability to comply with the bill that has been proposed by the legislature. Obviously, it's asking for quarterly data statistics, which we agree. Anytime we could provide information to the public, it's imperative. I've never found your office not to provide me information. You just provided me some ticket information upon request, which I was able to provide at a public meeting, so I appreciate that as well. But if we want to codify it with the law, I guess that's the prerogative, obviously, of the legislature. But in regards to the piggyback on what Legislator Gaylor said, the police department is tracking some level of data and statistics as it pertains to the current bail reform bill of individuals that have committed previous crimes, and be able to compile that data and provide to the legislature on whether or not they've recommitted other crimes or any other crime?
So we kind of knew that was going to be coming as one of the, looking at data. Look, our analysts do that. That's what they project problems and issues, part of the think tank. So we have been collecting it. It's not an easy data set to collect, and the reason why it's not going to be 100% accurate, because I don't know the village arrest. I don't know sometimes if the state took that arrest. I don't know what that agency that took it, what the outcome. So it's going to be work to search it and get it, but every data can be gotten once we put the effort into it.
So, like, say, for example, if someone was arrested in the village of Hempstead or the city of Glen Cove, you don't have that information accessible to be able to determine or compile their criminal history to provide to the legislature to determine whether or not you've captured all of their activity, or is that, if I'm understanding you correctly?
No, if we're talking about criminal history, that's one thing. We can access criminal history on anybody when we have the right reasons to access that
Okay.
data. But if we're talking about those that have been arrested and then released because of the new bail reform, that data to track that is work. There's a lot of work involved because, like I said, we do 50 arrests a day for the police department itself. Then I have my villages and my cities, and as you just heard, the state police are also in here, and we also have federal agencies that come in. But if they process them on a federal level, it's not my issue. But if they do it on a state level, then I got to track it.
I guess what I'm driving at is there a way for us to look at the data, whether they're released after January 1st or before? Is there a way for you to provide data with us that we agree that when many of the reforms came in place, you want to give it to people that obviously, as described, nonviolent, or people, as you admitted, many that are sitting in jail that don't deserve to be there because they can't pay the bail. But I think what we're trying to also take a look at in the situation of Mr. Maldonado's son, this allegedly, this gentleman committed several crimes leading up to that crime, which devastatingly took his son's life. Do you have the ability to provide to this legislature statistics, not by name, of course, but statistics that would give us some level of idea the activity of the individual that is being released or multiple times released until there's revisions to this bill?
Yes, we can. Yes, sir.
I don't know, I'm asking this question, I guess, to the majority. Is that encompassed in your bill in terms of some of the data gathering?
We'll look at it. We're trying to gather as much data as possible.
It is.
obviously, but-
It's part of Section C of the bill is the number of crimes charged against the defendants while such defendants have been released without bail on previous criminal charges or charges including the charges against said defendants and a brief narrative description of crimes allegedly committed while released without bail. So yes, we will be part of our
But
tracking.
if there's an area that's not covered, we'd be happy to consider amending the bill to cover that.
Okay. Well, I'm glad you're able to compile that data, Commissioner, and at the same time, I'm glad it's actually covered in the bill. The next area I wanted to dive into is, you alluded to it a little bit, but I know the legislature passed a contract which would help the police department as well as the district attorney in being able to manage and be able, with the discovery process. Is that software up and running fully, or is it still in the process of being up and running?
It's still a couple of months away from being up fully running, and the reason being is that the procurement process takes time to get them online. They are part of Motorola, so they came in. They do know some of the programs already. They've expedited a lot of the things that we need to do for us to make it more electronically, and we still have a lot more to go forward with them, and they're still working with us as we speak.
Okay. So when do you envision being able, I know procurement is
No,
is
we're up.
difficult in
The
Nassau County.
procurement process is all done. They're in.
So I guess when do you implement the system will be up and running?
I think
at
we're
100%?
a 3 to 6 month window is what we're looking at right now.
Okay. Okay. Commissioner, once the system is in, do you believe that will address some of the lack of personnel needs to be able to address the reforms to bail reform?
Anytime you add technology into something, it's going to make my game faster, absolutely. It will alleviate a lot of people sitting behind machines manually pulling data that we never thought we would have to pull. So, and we've done our own changes in the system to make our blotters, trying to make them electronic, trying to make our police officers' memo books electronic. So in one aspect, it's changed the way we do policing, that's for sure. Some good, some bad.
Okay. Thank you, Commissioner.
Welcome.
I just have a couple of follow-up questions. I think Legislator Rhodes has some questions. Has the new law changed the way your officers gather information or prepare for information in light of the fact that it has to be turned over, I think, within 15 days in the first instance? Is there any change in the procedures of your cops on the street,
So one of the things,
or
and
detectives for that matter?
and we changed the memo book. So the memo book is what the cop is, their Bible, if you will. It's how they gather their data. They put it into this memo book where they go, when they take their breaks, when they stop somebody, the plate data. We've taken that out from a written form and we made it electronically. So a little learning curve for that. And then also, will there be reluctance to put in as much data? Yeah, I assume so. But again, the memo book was always subject to be brought into court when asked for. So again, it's one of these catch-22 type things. Yes, it's changed the way we do it. Yes, eventually that memo book may have been called in by the time of trial.
Okay, but it has to be done on a more expedited basis at this time.
Absolutely. Everything completes, we try to complete by the end of tour, which extends our time of working.
Next question is more, I guess, of an anecdotal nature. Are your officers finding that suspects are aware of the new law?
I really can't answer that. I don't, look, you heard from Mr. Maldonado a minute ago that what that subject said. I have not specifically asked that question. I've heard anybody say it to me, but they do quickly learn about the laws pretty quick out there.
Now, I know it's still early. Are your officers indicating whether there's any change in the willingness of victims and or witnesses to cooperate?
We are seeing that attorneys are jumping in much earlier, and we are seeing that our cooperation, it depends, on the case and what the charge is. If they know they're going to be walking out on a minor drug charge, they're not going to cooperate against their drug dealer. That's, if we look at our victims again, and that's what we speak for. When you look at an overdose victim and you're trying to deal with a very upset family and that information of, hey, who's your dealer? Let us work to go after the dealer. Keeping them out of it and trying to work on the data, phone records, and so forth, that reluctance, we're concerned that they may rise. Have I seen a concern? It's too short of a data set to tell.
It's too soon. I think more I was focusing on a victim of a crime or somebody who's witnessed a crime, who may be concerned to have their information disclosed immediately. But as you said, it's too soon to really tell.
Way too soon to tell.
Okay. Legislator Rhodes?
Thank you, Mr. Presiding Officer. Just a couple of follow-up questions. There was an indication, you had made an indication that there was an uptick in crime by about 5%, not at the hearing today, but a previous statement that you had made. Do we know over what period of time that is? Is that just from January 1st?
So the number is still, the total crime has been, is up 5.5%. It's from January 1st to as of this morning, so it's the most up-to-date data compared to that same period last year.
Okay. And is there a breakdown between violent crimes, property crimes? Are we able to break that down any further?
Yeah, so actually our violent crime has seen a decrease, not an increase. But our property crimes and quality of life type crimes have seen an increase.
And do we have any idea what the reason for that might be?
Most of the individuals that we do arrest, if you look at the quantity of numbers, to give you an example, our grand larcenies are at 432 for the year, but if you looked at a robbery, it's only at 13 for the year. So it's a different type of crime. We get more people that commit grand larcenies, pettit larcenies, stealing property, shoplifting. So that number has started to climb.
And those are the crimes for which obviously there would be no bail.
That's correct.
Prior to January 1st of 2020, would there have been bail for those crimes previously?
I'm going to say probably not. So most of our shoplifters may not. They may have gotten bail, $100, $200 at the station house. Those that commit, but the problem is it's not the one crime. So the person we concern ourselves, and look, here's the difference of what we're talking about, that discretion that needs to be put back in there. I break into a car and I steal somebody's money out of the car, and I committed one pettit larceny. I break into a car and then I do 20 cars tonight. That person should not be going home on bail. That person should be staying in to see the judge the next morning to make sure that maybe, just maybe, we can get him, he's got a drug problem, and we can get him in front of diversion court, or he's got a mental health issue, and we can get him into some kind of substance abuse program. The system was built on us learning from our mistakes, that we know how to work and treat our subjects and our victims better. So, again, it's that discretion. So it's not a blanket answer one way or the other. First-time shoplifter, Roosevelt Field, almost always going to get an appearance ticket. Some that has multiple and has a history of shoplifting, and we know that person is a career shoplifter, probably not going to get bail and going to be remanded. And then when it goes down to court, then it's up to the courts what the court's decision was.
Right. Now, obviously, larceny, grand larceny, vehicular manslaughter, these are things that typically would have received some type of bail in the past.
Grand larceny, we would have always taken bail, and we would have probably mostly sent it to court.
Okay. And, you know, in terms of well, actually, if I can ask, what crimes do you keep track of statistically as of today? What levels of crime?
So we keep track of all crimes. Any crime that is committed in Nassau County, we have a number for. But what we report and we're required to report to the state are our major crimes. And the major crimes go from murder, rape, criminal sexual acts, sexual abuse, robbery, commercial robbery, street level, assault felonies, burglary residence, burglary commercial, stolen vehicles, and grand larcenies. They're our major crimes. And then when I give you a number of our total major crimes, I give you that number, then I give you a total crime report. That includes all others. So to give you an example, so far this year, there's been 677 major crimes committed in Nassau County. All other crimes, which are the smaller crimes, there's been 2,216 of those. So you see the volume of what we're talking about. And they're the ones that go out, and if we don't put them into some path, if you will, they go out and commit more crimes, and that number will grow. And that number is up as we, almost 2%.
And to the point that you made, for example, if someone is arrested on a drug crime and they may themselves be a user, in the past you'd be able to get them into some sort of drug interdiction program. Obviously you can't do that. You're releasing them right back into the same environment that they came from. So it actually, in theory, does harm to that prospective criminal defendant.
We like to think that the system has been working to take care of those and get them in the right path. I know we've worked very closely with Judge Sullivan over in diversion court and the DA's office on our opiate issue, and getting those kids into diversion court is very important.
Now, can you tell me, in advance of January 1st, how many people were released from jail in anticipation of the criminal justice reforms? I know, because there's been some dispute about that number. Initial projections were somewhere in the area of around 300, but then some some were not receiving bail before January 1st in anticipation of the reforms. Do we know what the total number? And apparently they were also released over a period of time, not just on December 31st. Do we know how many were actually released from the jail?
I'll just jump in on that. It's a complicated situation, but I'll have to give you the answer. So there was 3 or 4 spot checks by the sheriff's office throughout the year since the enactment of the law to gauge how much of the inmate population would be mandatory release as of January 1. So it always hovered around 300 to 400, and September was a good reading of what would have been the differential of overall jail population. My office, realizing an inevitability, started changing bail requests, also in line with judges realizing an inevitability who stopped granting bail requests. You know, because you eventually would get to the impossibility or the ludicrousy of a situation where if you ask for bail on December 30th for them to get on January 1, you've just cost a bunch of pieces of paper, possible liability for the county, unnecessary prison transport, things like that. So you would see, of course, because of preparations, the tapering from September to January gradually, not suddenly. That's why there's no big release on December 30th, because that would have been irresponsible. The jail always has people coming and going. It is a temporary detention facility. It's for only misdemeanor sentences or definite sentences of 1 year or less. It's not a prison. So there's a natural release pattern to that jail of people who have completed sentences, whatever they might be. That's what you would see released, and as less people were coming in and the same number of people were coming out,
That's what led to a gradual decline from 300 to, I think, on the night of, there was around, a few dozen. So as a result of preparation.
I'm assuming that the inmate population is the numbers of the average inmate population are maintained on I would assume, a monthly basis, right?
You would get the most accurate information from the sheriff, but how often they audit their jail population.
Okay. Do we know what the average inmate population was before the release and what it is today?
My recollection was it was over in the low thousands. My estimation would be about 1,100, 1,200 at a given time.
And do we know what it is today, or
I
we
do
don't?
not.
Okay. Incidentally, for the numbers of individuals that either were not retained on bail in anticipation of the criminal justice reforms taking effect on January 1st, and those who were actually released in anticipation of January 1st from the jail, are we keeping statistics on those individuals and whether there's been any incidents of recidivism?
Sheriff?
We're crime strategy doing a little bit, but
We'll be looking at all that data. Again, the sheriff's office would know more and should comment on that. But we do track a lot of the recidivism. We do track, what comes back around at us. Again, but working out percentages and stuff, that's not what we normally do. That number usually comes from a state level. But again.
Well, I mean, I would imagine, we know the individuals that were actually released in advance of criminal justice reform, right?
Again, so much of it wasn't about release. So I guess maybe I wasn't clear before. It wasn't as if there was a bunch of applications between September and the end of the year and people consented to release. What actually happened is the bail applications at the outset of a criminal case and the determinations at the outset of new cases from September to December were impacted. So rather than people getting released, they just didn't go in at the same rate. And then the natural attrition of the jail from September to December, you saw drive it down. Judges were also instructed in the final months that any time a case came up before them, to give a hard look at that person, maybe do a bail app before. Some were doing bail apps on the spot. Some were signing bail commitment release, post-dating them to December 31. So there were some people that the courts were not willing to release early. But your release population was a small factor of the reduction. It was actually the entry that decreased. Does that make sense?
No, it absolutely does.
So it's impossible to track the people that we never put in, so to speak.
Right. Yes. Completely understood. However, there is a subset of that population that actually was released.
That's correct.
For the ones that were released, and I guess we don't know the exact number, for the ones that were released, have we already begun to track whether those individuals were picked up on other crimes while awaiting their trials?
I'm aware of a few examples, but I don't have the full statistic. I'm, of course, aware of a few examples where we've gone after people who released, absconded, and we had to pick them up again.
Now, in anticipation, I don't know if it's, I guess it would be ADA Painter. In anticipation, I think you indicated that there was a policy decision between the judges and between the district attorney's office that we would not be seeking bail on certain crimes, because again, what's the point of putting somebody in jail on December 30th only to turn around and release them on January 1st? Was there coordination of those policies were there conversations between the DA's office and the judiciary? How did that work exactly?
I would say that's one of those things that occurred organically. You had a lot of honest and good and rational argument from the defense bar to the judges saying, Judge, this is not even a qualifying offense in 3 months or 2 months or 1 week, so why?
Right.
And you had a lot of judicial reception to that, again, which would be rational. So then when you have those factors, organically, the ADA at the beginning of a calendar will know what to ask on, what not to ask on, what the judicial proclivity of the day would be. So you'll see that just happen organically. As far as a top-down policy, wasn't even really necessary. There was a few lower-level cases. We're talking very B misdemeanors and violations where we pretty much said, okay, we should not be asking for bail on this anymore because there's no point they're getting out. But that's, again, a tiny fraction of what I would consider was more organic construct.
Okay. And I know Presiding Officer Nicolello had asked Commissioner about the effects of the new reforms on witnesses willing, or victims being willing to cooperate. I guess, and I believe you indicated it might be too early to tell.
It's also it's a hard stat to collect, because if they don't come forward, I don't know who they are. I guess, look, if we have willing witnesses that come forward, they help us solve crimes and they help us reduce our numbers. So I guess we'll be looking at the number. The only number that I can confidently give you is our crime numbers. That's what we collect. And, we watch and gauge how they work. But again, and I do add that Jack Maple's statement that crime is affected in the short term by weather. We've had a very mild winter, which bad guys do not like the cold. So crime goes down in January and February. But this time it's going up, but look out, it's another warm day here in Nassau County.
Sure, sure. I guess what I'm trying to get to is, in the example that ADA Painter gave to us during our budget hearings, where you had a victim, unfortunately, of a rape, and under the disclosure requirements, the prosecutors would be required to turn over the victim's name, the victim's contact information, and could, if the victim did not answer the phone when there was an attempt to contact them by the defense, potentially they would be able to receive their home address.
I'll be covering this in my presentation.
Oh, okay, not a problem. I guess the question that I had was, do we see a reluctance on the part of, in these particular instances over the course of the last month, do we see a reluctance on the part of someone who has reported a crime, then finds out what has to be disclosed, and then says, hey, you know what, I want no part of this? Have we seen that yet?
I'll leave it to the discretion of the presiding officer if he wants me to answer that now or go into my presentation, because I'll cover.
I mean, if you're going to cover it anyway, then
yeah, okay.
don't even worry about it.
I know that the commission has to leave by 1, correct? 1?
I'm good as long as James is there. So yes, I'm okay.
All right.
So I'm good till he speaks.
Last couple of questions for Pat, then I'm going to break it off, and we'll unless no one else has questions, you'll be off the hook, so to speak. Just, has the police department considered any strategies to give witnesses some level of comfort as to their security and protection while the criminal defendants or prospective criminal defendants are awaiting trial?
So always working with our district attorney, we've always taken great lengths to protect our witnesses. Whether we're going to put them up in hotels or move them out of the area or relocate them, that's always taken into consideration. And again, many times the victim says, no, I want to stay. This is my home. I'm not leaving. And we understand that. And then we try to intensify our patrols and stuff. You can't watch a victim all the time, unfortunately, unless you got them in a controlled environment. So we do our best to do it. We coordinate with the district attorney's office, and that has continued to be our plan going forward.
Now, I'm hoping that we'll receive some sort of update. As you know, the legislature passed in advance of criminal justice reform here in Nassau. It passed a bill calling for the creation of the Office of Crime Victim Advocate, which is actually going to serve as an advocate on behalf of crime victims that can actually go into court and either oppose applications or at least be heard on applications where information concerning victims and access to victims is going to be requested by the defense. Do you know if there's any update with respect to that, and has the police department been asked to coordinate with the Office of Crime Victim Advocate?
I'm going to leave the administration to answer that because I am not in that process. There may be some of my members working on it, but I don't have firsthand knowledge.
Okay. I appreciate that. And I know you indicated that you hadn't been contacted, I guess, by anybody at the state level in advance of criminal justice reform being voted on and presumably being implemented. Have you been contacted since, while we've been talking about reforms to criminal justice?
So I've had numerous conversations with many of our state senators, and all constructive, trying to understand the ramifications of this. And I also understand their argument on their side of what they were looking for. So, yes, we have. And I think that many of those items that you see in Newsday today are similar to what we've been talking about as our committee.
Mm-hmm. And if I can ask, what recommendations would you make to the existing criminal justice reform and cashless bail reform?
So we were asked to present that, put together a committee, present our issues, both from many different groups. That document will be sent to all of you today. I read it off before earlier.
Okay, I appreciate that. Thank you very much, Commissioner.
Thank
One final question, I apologize. We see down the pike potentially cannabis legislation coming down from the state. Sort of similar to the discussion we were having with regard to legalized marijuana for non-medicinal uses. Has anybody from the state contacted you for input with respect to that potential legislation coming down the pike this year?
Yes, there have been conversations regarding and discussions about it. I can't go into those conversations as of yet, but I will tell you that there was concerns in both sides, and I think I'd just rather leave it alone today, if you don't mind.
Understood. Thanks, Commissioner.
Legislator Drucker.
Thank you, Presiding Officer. And as often happens when I follow Legislator Rhodes, my questions were already asked and for the most part answered. But I do have a couple of follow-ups. Thank you, Commissioner. And you have no greater fan than me in terms of what you do in Nassau County in terms of protecting us and keeping us safe. I just wanted to piggyback on Legislator Rhodes, and also just to comment. I mean, I agree with Presiding Officer, Minority Leader, Legislator Ford. We all agree that there has to be changes to this law. But in the meantime, though, we have to deal with what we have. And I just had a question to follow up on Legislator Rhodes with regard to the increase of 5% you said regarding petty offenses. So you said that there are about 50 arrests per day. What percentage of those 50 arrests are for petty offenses, would you say?
The majority, I'd say almost 70, 75%.
70, 75%. And would you agree, because it's been my experience, that prior to January 1st, a suspect arrested on a petty offense, property damage, etc., would ordinarily be given a desk appearance ticket anyway?
Again, it would go into that discretion and that volume looking back. You know, how many did he do tonight? Did he do 7 or 8 of them? He's a persistent offender for us. He's causing us that problem that continues in the community. So we would hold him down to court.
Right.
Down at court, he'd probably be offered bail, and if not bail, he would be remanded.
Right, but I'm referring more or less to the person who's maybe done it once.
First-time offenders almost always on a low level, like larceny from a vehicle, would probably get an appearance ticket.
Right, so the new law really had no effect or has no effect on those type of circumstances.
No.
Right. Okay. Yeah, the rest of my questions were asked and answered. Thank you, Commissioner.
Thank you.
Okay, I think we're set. Thank you, Commissioner.
Thank you.
We have Mr. Painter. Would you
You're on
go
your
ahead
own,
with your
kid.
presentation?
Thank you very much. Okay. Again, I'm Jed Painter. I'm the NCDA General Counsel. Since April, it's been my main responsibility to ensure legal and policy compliance with the criminal justice reforms. I wanted to use this time, when we received the invitation, I was trying to think how to use the time productively, and then understanding the body I was in front of, what the body was capable of. And I wanted to actually open by saying that you all have been very good to the Nassau County DA's office, and we really appreciate that. You have always asked for our input. You have always acted on that input. We've come here many times, you know, with different budgetary requests, not just now, but in the past. And no matter what disagreements there might be, you've always made rational decisions. So we really do appreciate that and appreciate your support, and also appreciate you listening today. I did want to start by mentioning some positive effects of the criminal justice reforms. One thing that was negotiated on the way in to these, because we knew we had to offload a lot of cases early on, is we negotiated with the administrative judge earlier court dates, more frequent court dates. Misdemeanors are now heard at the 7th day and the 14th day. Felonies are at the 3rd and 5th day. and then adjournments to follow. But that upfront action on a case, that will pay dividends as far as total cases in the system down the road. It's an ancillary effect, but a good one that I would have wanted with or without these reforms, and we're happy we're seeing that, and hopefully by December you'll see a lot less cases just held up month after month adjournments. Second thing that probably would not have happened, but I count it as an ancillary effect, is we built and deployed an electronic discovery system, and it did not crash on day 2. It has now over 4,000 successful downloads from it. It's had over 300 registered users, so that was also a thing. We were very concerned about adoption by the judiciary, by the defense bar, but now opting out has become harder and harder. And again, this was something that the DA's office made. The court system didn't make this. We made it. It cost money, but we made it. And very happy that now we do have an electronic system of fast exchange. We've acquired data management software that would not have otherwise been urgent enough ever to be done. But we have many modes of transferring data between the various police departments that I mentioned. Like I said, I sat next to Commissioner Ryder. The NCPD is responsible for 79% of our reactive volume at the DA's office. But we work with 25 other law enforcement agencies, NYPD, federal partners, so we do have a myriad of sources that we have to work with, and we have to have data platforms for each and every single one of them. And the final thing is, I believe throughout this process, because it has been arduous, we have had a shared experience, and I do see police and prosecutors actually understanding one another's work better, understanding our procedures better, which I think organically makes a better criminal justice system. So I just wanted to mention those 4 things that were positive. That having been said, we have major practical issues with the deployment and implementation of these reforms. I'm going to cover a few of them and try to give them a little bit of a face. We will be trying our best, and we have been trying our best, and with the resources we have. The first thing I wanted to point out in any discussion in the ether, we see a lot of suggested amendments and whatnot. I want to draw a sharp line at the beginning between content versus timing of discovery. The process by which these reforms came about, I have found, could have benefited from a lot of substantive input, because it's very, very hard. The criminal justice system has a lot of workings, and saying terms like discovery and bail and securing orders, they're easy. But I think that were I to design a car, I would know it needs wheels and a hood and an engine and seats and seat belts and things. I could probably design something, but it would not know at all how to start. It would not work very well. So that's the kind of, without input, that's the kind of result you're going to have. So, and now I fear there's been a lot of easier solutions like, well, we'll just make 15 days turn to 30 or turn to 45 or turn to 60. That's actually not the main issue. The main issue is the content of discovery. I will show some examples of the types of data that we need to acquire. They are not stacks of paper. They are technological sources. They are body-worn cameras and GPS records, thousands upon thousands of memo books, surveillance video systems. It goes on. It has proven extremely difficult to file certificates of compliance with our discovery requirements on major cases. Having personally interviewed most of our litigation staff and discovery compliance staff, I can tell you this. So major case, major offense bureau, homicides, pattern criminals. In the 6 weeks it's been, one of those ADAs has been able, with her caseload of 30, has been able to certify 1. Another has been able to certify 3. All right? That is because on a homicide, you have crime scene, multiple different parties from whom you need to secure documentation, videos, detective reports. On pattern cases, you have that problem exponentially. The harder the case, the more important the case, much harder it is to certify, and like I said, it's not necessarily the DA's fault ultimately. They're the end user of a huge funnel for information. Ancillary documentation is holding up our certificates of compliance, and I'm talking about the 8th, 9th, and 10th officers who showed up to a scene, just probably for traffic control. Right now, the judicial trend that we're trying to reverse is we have to secure their memo book entries to say at certain hours they went and secured a traffic scene. Blotters of where evidence was moved or when a detective signed in or out. Very ancillary. Would probably never inform a plea, would never really a plea decision, or really come up at trial, but because the way the law was written is all items and information that relate to the subject matter of the case and then has a list of illustrative factors, and we're responsible for police records, the actualization of that constructive possession is almost impossible. And what's holding up things is very immaterial, and that can be very frustrating to the ADAs who have about 200 cases. Another thing is the lack of governing case law. It's too early. We see a bunch of lower level court decisions and they're all disagreeing with each other right now. It'll be about 6 months to a year before we see appellate guidance on what terms like relates to the subject matter cases and where the limitations of victim visitation go and all these other issues that don't give us too much comfort in what we're doing as a practice is right. We can try to do our best in good faith. We'll see where that leads us, but because it's a new law, and there's no court interpretations of that law, the default is grab everything, or the default on the judiciary is don't let them certify until they have everything. So content versus time of discovery is amazing. The biggest issue with the police departments, every single one, not just Nassau County or the villages, but across the state, are these radio transmissions and electronic records. I would go so far as to say, and I absolutely will say, body cameras, strongly discouraged now, again, not by anybody in particular, but because the data, the storage, the transmission, and the technology, as far as the acquisition, is too vast. There was a decision in the city where the metadata behind the actual cameras also had to be provided. I don't know. So I wouldn't expect to see, I thought that was a good direction to go in for accountability purposes, body cameras. Only one department has them, Freeport. I wouldn't see any immediate expansion of that until things cool down. Radio transmissions we've had to do in a completely different way. Police communications used to have a steady stream, and to identify what relates to the subject matter of the particular case would have to listen and edit and cut and put together the transmissions that related to that case. That was very first abandoned. Now we will just give the whole 1 hour unredacted from beginning to end. And because that can't even be done on the transitional caseload of 7,000 to 8,000 plus the incoming, they have a staff of 4 or 5. I've met with all of them. They can't do it, so we had to file an affidavit with the courts that we still do to this day, signed by Jane Gaddis, the communications supervisor, that outlines the impossibility to comply, but the alternative is if you come in, you can listen to it. And so that we established a listening station at police headquarters for that to happen, and even that is a heavy lift, and even that might not be judicially accepted, but it's all we can do to preserve our cases from being dismissed for 3030 grounds or speedy trial grounds. I apologize. GPS data, we've had lots of arguments about that. Every patrol car, another good thing, is tracked. And so we know for officer safety where they are, and if something's gone wrong. Station house video is another thing for security, very important, but to accumulate that data on every single case, like a traffic stop where somebody's brought in and processed, for aggravated unlicensed to get the station house video, I mean, it's something that would never even be considered. And we're, of course, going to be making legal arguments that it shouldn't be considered, but again, until there's a lack of study in case law, we are compiling a lot of information, or attempting to. Memo book entries is a huge issue. Officers don't carry one memo book. They carry sometimes multiple a month. And because the discovery is retroactive to all cases that were pending, identifying those memo book entries and pulling them in for those transitional cases, we sent a list of it was a computer compiled list of the memo books that we knew about as far as the officers assigned to cases. That list was 26,000 entries that cannot be pulled by the police. Absolutely not. They will do their best, but we will be eating sanctions on those and taking different tacks on those legally, making legal arguments where we can. That's just retroactive. Blotter entry is the same. There are 6 different blotters that possibly could exist for any given case. And scientific and technological data, of course, is a major issue. As far as you don't want to ever be put in a position where you're ignoring science because its discovery is voluminous. I wanted to show one example. It is very difficult to explain to a non-practitioner what I mean when I say our ADAs are really struggling. So I'm flashing an example, and I will zoom it a little faster in a second, but this is one portion of a defense request on a case. One portion. This is the portion of their defense request that pertains to forensic science. Okay? Controlled proficiency results for each analyst and technician responsible for preparation and analysis, including raw data, reported results, target values, acceptance ranges, copies of traceability documentation for standards of reference period during analysis, copies of technical procedures and effect at the time the test was performed, including sample preparation. I'm sorry, it's on the slide. I don't want to read it so slow that everybody falls asleep, but sample preparation records, including dates and conditions of preparation, procedural reference, purity, extract volume, bench notes, log books, measurements regarding taste testing, instrumentation run logs, run sequence, origins, times of analysis, records of instrument operating conditions and criteria for variables, gas chromatograph column, instrument file identification, tuning criteria, instrument performance checks, records of instrumentation maintenance at status and activities. We also have raw data. Down here you see a description of the library and reference spectra. Then you have copy of records documenting computation of laboratory's theoretical production yield, operation of calibration checks, results of calibration checks, and mass traceability. Okay, bum, bum, bum. I'm not going to read all of this. It ends with, and the procedures manual and the training manual. I just want to highlight, if that was at all boring for any of you, our ADAs still have to read it. Okay? They still have to read it. They forward it to me. I still check with the director to see what can we get. Because we have a presumption of openness. We have a due diligence and good faith requirement. I highlight. This is one nugget of discovery that relates to the forensic. It doesn't relate to the body cams yet, or the station house video, or the GPS, or the police reports, or the witness statements, or anything else. It is one nugget of a much bigger case of collection that's part of one case of which that ADA, this will take long to load, has 90. Okay? I want to say at this point, it's been 6 weeks. Every ADA who is in the front line of this reform right now, who is in court as I'm talking here, who has worked to modernize their caseload, they are an absolute hero. They did not deliver babies. I know there's legislative recommendation for such things where none of them delivered a baby in the backseat of a car or stopped a robber or ran into a burning building. But every single ADA who works at the Nassau County DA's office, who gutted it out under extreme adversity and still continues to do so, absolute hero. All right. As far as public safety issues, our witness protection expenses, we have received more requests for witness protection this month. It's been double this month than all of last year. So that will be adjusting our budget accordingly. Protective orders, the thing that would stand between the rapist knowing the victim, because you still have to file it. It's not presumptively protected. You still have to have that conversation with the rape victim about, I can try. I can't promise you anonymity. I can try. Try through a protective order. I remember last year, I saw the debates in the state level. If you read the transcripts, the state was under the impression that prosecutors tried to correct that protective orders were easy to get. And to the credit, I've seen the transcripts where they meant for this to be a low bar. You can see that in the transcript, a very low bar to get a protective order. We said, I don't care what you write, it's not going to be that easy. It's not that easy. We had two, now I'm trying to give small examples for time, but I want to mention two protective orders. Should have been no-brainers. One was a homicide, very violent homicide. The other one, one was an attempted murder. The other one was an MS-13 beheading, okay, as a violent murder. Protective orders sought, granted at the lower court level, expedited review goes to the presiding justice of the second department, vacated them both and sent them back for the defense to have input in those protective order hearings. Protective orders are not easy to get. And when talking on that line of questioning before about, how's it going communicating to witnesses, it is a sea change in communicating. Our prosecutors guide them through the process and tell them, come to grand jury and come to the hearings and come to the trial. It is a different conversation in 2020 than it was in 2019. In 2019, you said we'll protect your identity until you testify. No witness list. If it was that type of case, it was the type of case where we've had fears the prosecutor could use their discretion. It wasn't trial by ambush. It was discretion, and could seek a protective order if something came up. 2020, the conversation is much different. It's like we'll try our best, but I don't know. We have cases coming back on very violent things, so those conversations get shakier and shakier. But they are again had by the ADAs every day. Forensic unavailability. These discovery issues are not what people are talking about right now. I've seen a little bit of chatter on it. Most of it's about bail because you can see some more immediate effects of securing order reform. Forensic unavailability is a huge issue. We are about to lose all ballistics testing. All ballistics testing. Gun crimes, we're about to lose them. The state is down to, I think, their last analyst, and we've knocked on every door. Drug chemistry, again, our turnaround times are becoming abysmal. And again, I want to combat a situation where in the 21st century, I want to combat a situation where forensics are nuisances. It would be very easy to go to trial on a burglary with a confession and 3 witnesses. And you know what? Because of the discovery burden, I'm not going to test the latent print on the window, okay? Or maybe a DNA sample left at scene. Because I got my case is going to get dismissed if I wait for that evidence. So I'm going to go to trial, possibly have a wrongful conviction, because I didn't wait. That's a horrible thing. And believe me, we're counseling our ADAs, no, you're going to wait. But I'm just pointing that out, that you don't want a situation where science is the enemy, okay? Otherwise, 20 years from now, there'll be another person in this chair from the DA's office talking about that $40 million settlement. I'm sorry. Okay? There's been a lot of talk about some solutions. These are limited solutions because, again, content versus timing is 2 different things, as I hope I've illustrated. NICE Investigate is meeting benchmarks. February this month, they'll be starting to take some of the NCPD data into the cloud. By April, we'll start seeing mechanism of exchange, but they have meetings with us every week as far as implementation, and I would agree with the Commissioner 3 to 6 months is a reasonable go-live date. We've uploaded all calibration records to a website, so that way, instead of disclosing volumes of information, we can direct defense counsel simply just saying, hey, listen, this is okay to be public, just go to this website. We had that inspection station for the radio transmissions, and we've developed technologically cancellation platforms. The cancellation platforms are that every single time our case management system, this is, again, a credit to our IT department, Every time a case is now entered as disposed of, at the end of the day, the computer will do a run and transmit that to the police so they stop producing discovery because they are so on fire that getting them cancellations would help them. Same thing with the lab. Actually, that hasn't been finalized yet, but we're hopefully going to get the tech to finalize that. Any bit helps. We have ordered 60 scanners. One bright side I will say is that our copying is down and our ink is down 65% because of electronic discovery. I'd like to get that number even lower. Digital storage costs are going to go up. It's all going. We have terabytes of data now. There's a contract. Boy, I think it's been signed. It's just about moving it forward. It's well, maybe it hasn't been signed. It's the P1 Justware integration, where data won't have to be re-entered as soon as the Premier One system of the police, one inputted. Our system will automatically, the names and the DOBs, it'll save us a lot on data entry. We're waiting for that. And we're trying to hire more discovery expediters. Our core, we lost one, so we're down to 9. We have 9 discovery expediters, a senior ADA in discovery compliance, and a bureau chief. That's something we didn't have last year. We are trying to, because case files are going to be a thing of the past. We are putting so much into the digital files now that a case file is almost, why do we even need it? The only reason why we need it is because we don't have Wi-Fi in the courtrooms or tablets. But I would absolutely see, because when you're sending in an ADA into the courtroom now with a case file, you're sending them with nothing. Their case file is back on the computer. So we'll have to update that. And data entry enhancements, support staff hiring, those cancellation lists that I talked about only get produced timely is if we have no backlog, 0 backlog in data entry of dispositions. Because if we're not up to date, if it's like, hey, this is a month to enter the dispos from last month, the cancellations don't work, the discovery gets overloaded, and people are wasting their time. We've also been forced, because of the volume of all these exchange systems, to come up with a system of priority requests with the PD, memo books and blotters and ancillary documentation, we're actually taking on water. We have to wait until 50% of speedy trial has gone. So we are jeopardizing the cases in order to achieve a ultimately positive resolution, because it's one of those where the good of the many outweigh the good of the few. Other solutions, of course, is doing the right legal arguments about impossibility, and we've advanced many. Legislative solutions, I tell my staff that we shouldn't hold out hope to anything. We should try to adapt to things as they are now. More immediately is policy-based solutions such as plea offers, and yes, that might force us to go lighter, faster. It was mentioned before about marijuana. Marijuana is actually a non-issue. I don't know if people know this. The public health law was amended. Public health law was amended to include hemp. Hemp has a quantity of THC that has to differentiate from marijuana. As of March 8th, the lab will not be able to test marijuana because they have no ability to quant marijuana. So it doesn't matter if it's a felony, a misdemeanor, drunk driving or drug driving. Doesn't practically. They don't have the tools and will not get the tools back until September if they order them, the reagents necessary to test marijuana. So whether or not the legislature acts on anything further with marijuana because of the hemp amendment to the public health law that already has happened, as of March 8th, marijuana cannot be tested. Other issues. Phoenix alternative sentencing. We had a robust alternative sentencing platform. You know, it's good to get people appropriate treatment for mental health issues or drug treatment issues. The future of that is a little shaky, as well as things like communications investigative. We're spending all of our labor force on reactive. The proactive might be forced into the back seat, just as the NCPD explained their resource issues. We might eventually encompass support staff, line assistant, other resource issues. I wanted to flag this as just an odd thing, opioid litigation. The county is part of many counties suing opioid manufacturers. I don't know. I'm not privy to how many millions we're suing for or what our settlement prospects look like or anything. But what I do know is the DA's office is required to comply with their discovery in civil land. And the standing order right now is production of all heroin files from 1995 to present, an order that I've gone personally to court to say to the judge there's absolutely no way with present caseloads, present discovery obligations in a criminal context, I can comply with civil. I don't know what that does to the county attorney's suit, but if pressed between a situation where I'm doing production for a judge in civil court that's off our main constitutional mission and fulfilling our constitutional mission to prosecute crime and to do discovery, that's going to go. A constitutional obligation comes first. So I credit the county's outside counsels for working with me on that and understanding and trying to fight as hard as they can. It's not their fault that this was sort of the wrong year to do that, but I raise it because that's another ancillary issue of discovery production. The biggest thing, what I wanted to spend the most time on, is recruitment and retention. Staff morale is absolutely walloped if you're an ADA. Just absolutely, what a case was to do before is 10 times that amount. If you had a caseload of 50, you might as well have a caseload of 500 to 1,000 now. Every case, because you can't plea anything, universal discovery, the grabbing is just way too much. We have ADAs completely burning out. In Brooklyn, if you notice the article, they lost over 40 in 1 month. The previous record was 17. Okay? We know people are looking. These are talented attorneys. I want to point out that they're not easily replaceable either. This is the recruitment statistics for the district attorney's office for the past 7 years. There has been, as you can see, an 80% decline in applicants. 80%. If I lose them, I can't get them back. Just because 100 apply, by the way, doesn't mean I get 100 people. Those same 100 are applying to the Bronx, Brooklyn, Manhattan, Westchester, Suffolk. Okay? So say 20% of that number, then we have to like that 20% of the number and say they're competent. And the DA actually has to exercise discretion and say, I trust you to represent my name in court. Okay? We are in a recruitment crisis. And while we've dropped 80%, I know other offices, because it's part of my job, to survey, they've gone down, but in the city it's more like 30% loss of interest. We are specifically hit. Okay? I want to point out this, unlike when the last time we hit a big collapse, that was during 2010 to 2014 where it was a bad economy, okay? Where people were leaving because there was pay freezes and whatnot. This is a good economy. We have lost 2 ADAs who were poached for double their salary. We cannot stop that. We can stop people from looking if they enjoy their work, if they love their work, if they find nobility in their work. This morale crisis is very real, and it's caused directly by the workload and the abuse. Quite honestly, there's a lot of negative perceptions right now of the profession that I resent. As far as the ABA standards, we're mindful that we are not supposed to assign our ADAs a workload that by reason of its excessive size or complexity interferes with providing quality representation or endangers the interests of justice. Okay? It's dangerous for wrongful conviction. It's dangerous from a financial standpoint as far as liability when things get reversed. It's danger for the lawyer's individual ethics. They can be individually sanctioned. They can have grievances taken about them, and every single one of them is aware of that. And when we took a caseload of 90 to 200 cases and made the work associated with that caseload multiply tremendously with the discovery burden, we have to reassess what a caseload looks like. Now, ideally, I would come before this body and say, so we need to hire a lot more prosecutors to bring down caseloads. But as you can see, that's actually not why I'm here, because our recruitment, we couldn't hire if we wanted to. Even if you gave us the money, we couldn't hire. We have a recruitment crisis. We have to focus more on retention. This is what I'm doing right now. The chief prosecutor, on behalf of the chief prosecutor for a jurisdiction, inform governmental officials of the workload and request funding and personnel that are adequate to maintain the criminal caseload. The bottom sentence is the scary one. If we can't recruit, then we have to notify the jurisdiction and seek judicial relief, and I don't even know what that would look like. I don't know if it's ever happened. So I have surveyed many offices for what we're doing different. I've surveyed our own offices. I conduct the exit interview program, and I have for the last 3 or 4 years. One of the major lackings that we have in Nassau County, which we should be morally ashamed of anyway, is we have no paid child care leave. New York City has minimum 6 weeks, and they go up to 12 weeks, okay? When given the choice between those two jurisdictions, if you're one of those 100 applicants, you're going there. But even more importantly, because we rely so much on lateral hiring, where you might cut your teeth in the Bronx or Queens, and we're seeking to recruit you here, this is the practical situation of what happens. You're 24 years old when you get out of law school. You work for 3 or 4 years in the Bronx. You're now 27, 28, 29, whatever. You start looking to have a family, maybe move out to the suburbs, join the Nassau DA's office, okay? You're told that you're leaving 12 weeks paid leave for nothing. We have absolute anecdotal evidence that that is a complete bar to our lateral recruitment. We cannot replenish if we do not have that competitive edge. I'd also highlight that in under our rules for the ADAs, it would take 3 years of working here to accrue 12 weeks of vacation and personal time, and that's without taking anything over the course of those 3 years. So if you wanted to move, have a baby, raise a family in Nassau County and join, our team, you have to postpone those plans for a minimum of 3 years. You're not allowed to take any time for Jewish holidays or anything else that you might have to take along the way. You have to work straight. The NCDA houses approximately 45% of all ordinance employees, and our current gender spread, 65% female to 35% male. And the female cohort, 57% are between 24 and 35 years old. So now you're starting to see what's happening. Right now, they're using accrued vacation and personal time to accommodate child care leave. All right. Before I make my next point, I just want to point out, take a moment for myself here. I supervise an ADA. I've supervised her since she was my intern in Corruption Bureau. She lost her mother in her 3rd trimester. She was worried. She could not take off time to grieve her mother because she barely had enough stored vacation and personal, doesn't still, to take maternity leave. She would have to go unpaid. She's now out on leave. I couldn't even donate her time because the rules of donating time in this county require her to exhaust everything before she can accept that time. And then if anything happens for the rest of this year, flu, sickness, has to take any other day off to take care of a sick child, which is not impossible to consider, she just has nothing left because you're forced to give up your personal vacation. So horrible situation. If ever I wanted to put my head on my desk and, lament that I didn't bring this up sooner, that was the time. But moving on, this actually doesn't cost anything. It doesn't. As of March 1, 2019, because of some termination pay issues, this body, with I believe our input and support, capped termination pay for exempts at 30 days. Fair and reasonable, absolutely. Anybody hired after that time can't leave with more than 30 days banked. Paid leave, paid child care leave, costs you nothing during a budgetary year. We always budget for the entire salary, point to point, okay? What paid leave does is instead of going to your bank, you use some time that's awarded to you, meaning that at the end of your career, when you seek termination, you might have that exact 12 weeks still sitting there, hypothetically, because you didn't have to use it during one given budgetary year. But because this legislature has already capped the termination pay at 30 days, you do not have that fear of having the banked time at the end. They can't accrue more than 30 days. So, I would ask that as one mechanism to improve recruitment, because again, I was struggling to figure what I should never come here without a proposed solution if I'm mentioning a problem with recruitment. I think besides the moral benefits and the morale benefits, I think it's just it's long time to be competitive with New York City. Okay. As an alternative, like I said, the accrual of time is very slow. So if you want to move here or accept a lateral appointment, it'll take you 3 years before you come up with anything close to 12 weeks. And again, 6 weeks is the minimum in New York City anyway, without taking anything. Perhaps upfront accommodations could be made, or at least in the discretion of the executive of a department. Other things that we have to consider when we're talking about morale and retention is retention bonuses or re-signing commitments. You know, when they hit their 3-year commitment, maybe throwing something at them. We haven't decided anything. These are just, ideas. Retention-focused salary modeling. Westchester's very good at this. They just decided we're going to be a retention-focused office. We don't want classes progressing. Let's hold what we have, pay higher. When we lose a body, we get a body because we pay higher. And ECAB stipends. There's going to be a bill coming through this legislature soon. I hope it's non-controversial. We have an early case assessment bureau. I testified here a while back talking about how one of the biggest impacted fields was going to be our intake operations that was going to have to take on the discovery compliance operations. And you did take action on that. You awarded us some money to enhance our intake operations. This is a way that we want to deploy it. Our ECAB stipends had not been adjusted since 2017. They didn't allow for a supervisor differential. So it's a bill that we can afford because you have given us the money that we just need to deploy now. Again, early case assessment bureau being discovery compliance, that's the main functionality that we need to improve in the short term. And also as a plug for the bill, it's cheaper than hiring people because when you give out stipends, you're flat feeing it, whereas if you hire a body, you're paying them pension and health costs. That having been said, I'll take any questions.
First off, that was an excellent presentation. So thank you very much for that presentation. Also, please extend our thank yous to all of the ADAs that you're referring to today for the work that they're doing to protect our residents and for our county. And thank the DA. She's running an office that is a model in terms of being proactive to deal with these issues. And I know in particular that the DA was able to get grants for crime victims advocates in the office. So that truly will be helpful. I'm not going to go into it to have another meeting to run into for a little bit, but I'm kind of shocked with your description of what our ADAs are going through and what their workload looks like, and I'm sure we're all deeply concerned about that. And I think that in and of itself would be enough for a full hearing. We will explore the paid child care leave if there's a way that we can do that. But I did want to get into the lab results. I mean, that is a deeply concerning area also. In this age, obviously, the forensics, as you said, oftentimes determine whether or not you can prove a case or not. What can we do to improve that situation? It's an immediate issue, as far as I know. But what can we do to improve that situation?
Okay. We are fortunate to have our own crime lab. North of New York City, they're all using the state troopers. They're all using the state troopers, and that is calamity waiting to happen. You'll see those articles in another month or two when cases start getting tossed. For a while, I believe still they're only testing a felony weight, nothing else. We have our own force with a new facility. We have outside contracts with NMS that we've tried to pull back on, go back to NMS to help. We've tried to, on a policy level, limit what we send. This fact that the marijuana is becoming practically impossible to test, regardless of, I take no position, but regardless of what the legislature does later, they've already forecast that there's no point in sending the marijuana after March 8th. Other decisions like vaping, THC, things to hold back things that might be more minor, that might entitle to a very favorable disposition very upfront with those earlier court dates. We can do policy-based solutions, but ultimately, the laboratory needs staffing up, significant staffing up. You would have to get that testimony as to specifics from the lab. I can only relate anecdotally that we are trying to give them a break with, again, adhering to a 50% speedy trial goal, something that we might have to shove up to 60% or 70%, but we are trying to control when we submit. When I say 50% speedy trial, I guess I should explain that. On a felony case, you have 6 months before the case is tossed. So we are willing to take on 3 months of water, so to speak, before we even request. For a misdemeanor, it's 90 days, so 45 days. We have the benefit of a desk appearance ticket for most drug cases now, so actually that kicks up to 55 days, because you have 110 if you count the 20 days of DAT time with the 90 days. So 55 days, that's the turnaround we're looking for. I do not believe they're fully able to meet those targets, and things will only get worse. And when it comes to case validating, we need it, because the district attorney will not. The district attorney will accept a plea on a criminal possession of controlled substance case, but before the sentence, we will verify that it was a controlled substance. That's I think, a fundamental policy against wrongful conviction, that we want to know that you actually had crack, not sheetrock. So there's not much we can do there. So every single controlled substance case which takes a controlled substance plea, we will be seeking testing on.
All right, and Legislator Ford has already taken the initiative with respect to the crime lab, and it's something we will be following up on, whether it requires staffing or whatever it requires. It would have been a crisis situation in any event, but with the new disclosure laws, it just makes it more acute than ever. So, Legislator Ford?
Thank you very much for your presentation. Is it possible to get a copy of it?
Yes, of course.
I appreciate it. Okay, I think all of us would like it, because you had a lot of...
This is not my laptop. I'll just leave it on the laptop. Whoever.
Okay,
thanks.
Thanks, because, it was a lot of information. I think that's stuff that we would like to, look at more closely. Just a quick thing, and when you talked about discovery, with the proposed changes that they're considering now with the bail reform up in the state, will they, I'm going to say this wrong, will they keep with the practical issues, will they help with the practical issues that you outlined regarding discovery? When you...
I don't know. I would hope so.
Oh, okay.
I don't know their frame of mind on it.
Okay. When you talked about body cameras and with, I guess whatever data they get, from the actual, films and stuff like that are recorded, like the actions that are recorded by a body camera, I got a little confused. You talked about metadata. I don't know, what is that?
Well, think of your phone.
Right.
Okay, when your phone takes a photo, the photo not only is, you can see the photo, but it's sometimes geographic location of where the photo was taken, the time it was taken. Okay, and even if you get even further behind that, there's plenty of stuff that comparative data, so that sometimes your phone might accumulate albums based on face or time. So there are various software solutions where the metadata is important to jibe body cameras together, so you can actually view on a split screen one single incident. The point I'm trying to make is it's sometimes not just the image, it's a lot of associated data. We have a similar issue with wires. The amount of data is not just what you hear on the phone call, it's a lot of stuff behind it, a lot of GPS and other things, and it can go fairly infinitely if you let it. I mean, you can get to a situation where you're looking for the calibration records of the satellites in space.
Really? Because that was something that was brought up in the hearing when we had with the labs, and they were talking about this calibration. I'm not an attorney, so I may say the wrong terminology, but when they were discussing about the calibration, and there's I guess you have to when you're prosecuting and stuff, the defense will ask to make sure that the whatever the measurements are actually accurate and based on previous testing and as well as the person who actually did the calibration. They need to have information. So it seems that now they have to add more information because they have to go back farther in regard to providing some information in regards to the people as well as the instruments. So are you as a DA or ADA compelled to then also even add more background information in regard when you are prosecuting or going to charge somebody?
So as far as our preparations on that,
Yeah.
the lab also was technically brilliant and was able to produce a portal called the BEAST portal, which we use.
Okay.
The BEAST portal has pre-uploaded everybody's curriculum vitae, because we need that. It's preloaded proficiency test results of those individuals dating back to the time period required by statute or as far as the records go back. We have accreditation standards on there. They basically pre-populated with the generic data and the calibration records, and that was not a heavy lift, but they did it. That having been said, the document that I showed on screen and then broke down doesn't cover any of that. I still had to email the lab and see what's feasible with that and got various responses like, we could possibly produce this, we could possibly produce this, no, we can't produce that. And some of the answers to the questions is we could produce that, but you would need proprietary software to read it. And they do not have the proprietary software. They'd have to buy a license for it to just even view, the DNA profile.
And would that be the county would have to buy that software?
No, we would. I mean, no.
Yeah.
Some of this. I don't know how much of this is testing the system, how much of this is genuinely interested. I don't know. But if it came push to shove where a judge said, no, I find that the defense attorney can hire an expert to review the raw data behind the blah, 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 then you can arrange, you can have a court order to go to a viewing station at the lab that has a proprietary software, taking, of course, chemists off the floor to sit with you while you do it, and view the program.
No, I appreciate your testimony and bringing to light, the challenges, faced by your department as well as the ADAs. And yes, they are, they are heroes to be able, and the fact is that you all have basically worked with this and put it like a bit of a positive spin to a certain degree on something that seems to be so enormous, for all of us to comprehend. So I really appreciate even some of the steps that you've already taken. And please let our DA, Madeline Singas, know of our gratitude, for her foresight, in doing this. So, I don't know, is there anybody else? Okay, Legislator Gaylor.
Okay. Thank you, Mr. Painter, for your testimony today, and I appreciate your honesty and forthrightness in sharing with us. I know Commissioner Ryder mentioned diversion programs. I think you touched upon it. I just want to ask a couple questions in that regard initially here. So my understanding is before the bail laws were implemented, individuals charged with drug possession were eligible for bail.
Yes.
Would that be a correct statement? Okay. And often in lieu of bail, these folks were offered an opportunity to a drug treatment diversion program. Would that be a correct statement?
Yeah, there's a lot of different vehicles to get somebody some addiction treatment. It could be done on an outpatient basis. A judge could make a condition of release to be conditionally released to the probation department, who would recommend outpatient treatment, and then the person would have to abide by those terms of release, and if not, the hammer over the head was bail.
Okay.
So it's either go to treatment, or I'm basically a short form of go to treatment, or I'm going to have to put you in to control your habit.
All right, and in many cases, those drug treatment programs were successful. In some cases, they weren't as successful for that offender. But now we're in a situation where judges are given a choice of diversion program or and I should say the defendant or the principal or whatever the correct term nowadays would be, or I'm not sure we can call them defendants anymore from your previous testimony, but whatever they're called, they're given a choice now of a drug diversion program or it's no bail, so you're out anyway.
The only other way we can remedy that gap is doing what's called a contract plea. The contract plea would be where you plea up front, but the case is adjourned, and you comply with various things in your contract, which would be treatment focused, whether it's mental health
But
or
that comes down the
addiction.
road, right?
It comes down the road, and then
Initially,
you vacate it.
You get arrested, and, you know, you get to that first resolution part, I guess, after arraignment, and you can go to diversion or, you know, be released and come back and whenever. So what are you seeing, or are we starting to see, is where I'm going, with the number of cases going to diversion program plummeting? Because people are just saying, I don't want to do that, I'll just come back, maybe come back at the next court date or whatnot. So how are the numbers looking on diversion programs?
I'm going to say it's too soon to tell, but that having been said, you are right that there is a gap in immediate treatment because the application of DA-focused diversion cannot happen as quickly. We are in a post-contract world, meaning post-plea, which also means post-discovery. So there will be a delay between possibly a person's need and the criminal justice system able to do something about it. That having been said, they can always, you know, maybe the arrest itself can, I don't want to speculate. All I can tell you is what we can control and what we can't control. There is no ability pre-plea now to have a consequence for noncompliance with treatment alternatives.
All right, so, and I know recently the county executive at one of our press conferences mentioned that the numbers of folks going into the diversion program is plummeting. I think that was her word. And that there was, she was seeing, or the county was seeing, an increase in the number of drug overdoses. Do you have a comment towards that?
I believe that was the commissioner's fear last year, that overdoses would go up. My only comment is it is harder for the criminal justice system to mandate treatment now than it was. I'll leave it at that.
Yeah, okay, so you know, I think in today's paper I read that the Manhattan District Attorney, Mr. Vance, indicated 40 ADAs have resigned since January 1st because of the increased workloads associated with these discovery reforms. Do we have a specific number of Nassau County ADAs that have resigned since January 1st because they're just overwhelmed by the work and said, screw this, I'm not coming back tomorrow?
As you see me smiling, as sort of a badge of honor that Brooklyn lost over 40, Manhattan lost whatever number, that the heroes we have at the Nassau County DA's office, we have lost 3, which pales in comparison. So I really, they have my full respect for gutting this out. 2 of them were facing much higher salary offers. That is not to say more will come, but I'm hopeful that we continue to give our ADAs the support, the morale boosts, the legal arguments, the policies, and the resources that will keep them encouraged in doing jobs that they love. And as somebody who does the exit interviews for the office, nobody ever seems to want to go. They're usually enticed to go for something else. So all I'm going to say is that we have a really good crew, and I want to keep that really good crew together.
So are we working on a plan, as the district attorney, and maybe you, working on a plan where we foresee in the very near future we're going to defer or decline prosecution because of these increases and can't meeting the 14 pages you showed us of having to provide all that technical data? So are we starting to think about declining prosecution in certain types of cases?
I am aware of what you're talking about in other jurisdictions where they are deferring, which can be sometimes an only option. We have not had any policy discussions to go that route. We are only focused, where those shorter court dates, which we advocated for, that's what we wanted. We knew something was going to have to get cut but we wanted the court system to be involved, and so the pressure is on our supervisors to make faster decisions to remove volume. At arraignments, if possible, at the 7-day mark, if possible, at the 14-day mark, if possible. That's where the volume is in district court. And so our strategy has not so much been deferring. Our strategy has been more very fast decision-making to date.
All right. Again, I thank you, and I thank all the members of the District Attorney's Office for the work they do.
Good afternoon, Mr. Painter.
Hello.
And thank you for your testimony. Just like in October, it was very informative, fact-based, and very impressive. So thank you very much for that. I really just want to focus on kind of two issues here. The first is electronic monitoring. How often is electronic monitoring used now, and how often was it used prior to the new criminal justice reforms taking effect?
So electronic monitoring, there has been a tremendous increase. Probation has requested a lot more devices at $800 each. They lease them from a company. We received a memo from OCA that permitted our modeling of monitoring to work, where we can outsource the actual technology, but have to insource decision-making about the monitoring. So we were able to move forward, thankfully, with use of it. I do see requests for that going up, because sometimes it's the only alternative on felonies that are non-qualifying.
Do we have the infrastructure in place as a county to track those who are issued these monitors?
I would have to direct you to the probation department to see exactly what kind of staff they have looking at the screens. We have the hardware. We have made the request where we felt there was an appropriate alternative. And we've seen one or two non-compliances. We had that example of the guy who cut off his strap, and so it is a tool or a safeguard, but we try to use it only where appropriate.
Well, let's talk about the person who cut off the strap, and do you know how the police department's alerted if somebody cuts off a strap?
Yeah, you get what's called a strap alert. It's not the police department that's notified; it's the probation department that's notified with a strap alert. And and that specific case, because I participated in that because one of the early ones that I wanted to be personally involved with as one of the first flashpoints of electronic monitoring meeting reality. In that specific case, the defendant was charged with non-qualifying offense bank robberies. He had to be released. He was not. The judge in district court set bail regardless. It was very early days. Legal Aid took a 530-30 appeal to the Supreme Court judge. I appeared for that 530-30 hearing myself. I did consent to the application because it was illegal. And the judge granted the application because it was illegal to have him on on bail. I requested in the alternative, because the only legal option was electronic monitoring. He was fitted with electronic monitoring, released from the jail. His court date was set for a few days from then. He missed that court date. At the same time of that, him missing the court date, probation notified me that they'd received a strap alert. I went down to court. I informed Judge Berkowitz that there was a strap alert. Regrettably, it was too late. The case had been called, and the warrant could not be issued. It was postponed for 48 hours because that's the law. I went back on the Friday, the 2 days later, and then requested the warrant for his return.
So are you saying that the strap alert came in and you couldn't even request a warrant for his arrest for 48 hours?
It came in after the case had been called. So we probably have to tighten up our procedure of where probation sends the strap alerts when they occur.
What's the punishment for someone cutting off one of these devices?
What we would there's two possible penalties under the law. One is you can be charged with criminal mischief. In the case of the valuation of that property, it would be an e-felony, so ironically a mandatory desk appearance ticket. But concurrently with that consequence, you would have a possibility of being held in contempt of court, which you might have seen from My Cousin Vinny. The court could hold you in contempt and jail you for up to 90 days for a violation like that, because they've ordered you on electronic monitoring. So, and I did do a hearing like that on a related case myself with the person who kept on committing crimes, and we went for a contempt because she failed to report for electronic monitoring, and she was held for 10 days on just that violation. So that is available too.
All right, but that's, okay. So if you're charged with that e-felony, that's not a bail-eligible offense, correct?
On its own, no. What you would have to do, what you would have to do is, okay, so besides the immediate consequence of a criminal charge or possible contempt, and I say possible because it's only been used to my knowledge once. I've only seen judicial contempt used once in a decade.
But that could be used on any.
Could be used, but I've just never, it's a very rare thing.
Right.
The other option under the law is, because you've committed an additional felony by cutting off the bracelet, you could go back to the judge on the underlying case, the underlying bank robbery, and say under 530-62B of the criminal procedure law, look, they've committed an additional felony, and you have to do a hearing before the old judge, demonstrating by clear and convincing evidence the commission of the new felony. You have to, it's got to be a non-hearsay thing, so you have to have like a mini trial on it. So I'd have to produce the probation department, the GPS records, et cetera, before the old judge. If I satisfy before the old judge at that hearing that they have committed a new felony while out at liberty on the existing felony, I then have the right to ask for bail.
Okay, so this is a good segue to my next series of questions, because it sounds like you're doing what a responsible ADA would do in looking for somebody like this who keeps cutting off their device to be held. That's common sense. So it brings me to my next line of questioning, which is the new Senate Bill 7723, criminal circumvention of bail reform. Are you familiar with that bill?
I believe it was pulled.
But are you familiar with the bill when it was filed? Have you had a chance to review it?
Yes, I did.
All right. And this bill applies to police officers, judges, detectives, and prosecutors, correct?
It would have if it weren't pulled.
Right. Now, my understanding of the bill was that if charges are inflated against an individual, that the person, any of the ones we just listed, the police officer, ADA, could be charged with a criminal offense. Is that your interpretation?
The bill, as I understood it, would make it a Class A misdemeanor for a prosecutor or police officer to inflate charges, or possibly deflate charges, but I think it's only inflate charges, to circumvent bail reform.
And now bail reform...
Basically upcharge somebody.
But when we talk about bail reform, correct me if I'm wrong, written within bail reform is that judges must take all proper measures to err on the side of no bail, correct?
That's correct.
All right. So, to your knowledge, has anyone in your department ever intentionally overcharged an individual so that bail could be imposed on them?
Never.
Okay. And would you have supported this legislation, this bill?
It's a hypothetical question, but I'd rather just not answer. The bill's been pulled, so there's no reason to comment on it.
Okay. I mean, just the idea that a bill like this could be proposed, knowing the limitations that you've outlined so eloquently today, everything that's going on, it's really disturbing that a bill like this could even be drafted in the first place and submitted. So I am happy that it's been removed. But thank you for your answers. I appreciate it, Mr. Painter.
Thank you.
I know that you have a time constraint. How much more time do we have?
I could stay for another 20 minutes.
20?
Needed.
All right, thank you very much. Legislator Rhodes, and then Legislator Drucker. Okay.
Okay, then I will try and limit mine to about 6 minutes out of that 20. First off, I want to say thank you. the fact that you, and separate and apart from the DA's office, that you personally have been so upfront and forthright and sort of taking the lead in informing us as to the practical implications of a criminal justice reform, even before it went into place. I know that you have taken heat from a number of different sources throughout the state for being one of the first ones to actually articulate the practical effects and impacts of what would happen. We should never be afraid to tell the truth, and I appreciate the fact that that you have, and that I think it speaks volumes about those who would criticize you for telling the truth about their motivations. So I just wanted to start off by saying thank you, and that ate up about 90 seconds of my 6 minutes. Public Safety Committee heard testimony from the medical examiner on Monday when was speaking about delays of 60 days, 80 days, the backlog that continues to grow as they have additional evidence that has to be submitted for testing and production. I know you spoke about felonies having a 180-day speedy trial, and misdemeanors speedy trial has to be within 90. But there are other sanctions, according to that bill, that can be imposed for the failure to provide the disclosure within the 15 days that were set forth in the law. Has the county had to pay any sanctions yet, or do you even know what those sanctions might be?
It would not be financial sanctions. We would never pay them, but the 45th day is coming up soon. So we'll be having that conversation very shortly. I remember the January 1 effective date. You're looking at my math. You're looking actually at tomorrow to start beginning, looking at what we don't have. It would still be premature to even assess sanctions at that point, we would say to the judges, because what would happen on a practical sense is we would get something on, say, March 2, some memo book or blotter or something, turn it over at that time. At that point in time, a defense attorney would have to say, oh my goodness, if I only had this memo book 14 days ago, I could have done something.
Hired an expert.
And I'm prejudiced. Yeah, something like that. And that's the time to discuss sanctions. It's actually upon the late disclosure that the dialogue can start to ensue. We're not there yet.
Is there a prejudice component to it?
There is absolutely a prejudice component, and we'll be arguing that, that the sanction has to be proportionate to the level of violation.
So now,
not turning over a witness statement of the accuser would be punished much more highly, of course, than the traffic control cop's memo book.
Right. So, for example, you could be, in theory, precluded from using the memo book, or precluded from offering that officer's testimony, just in theory.
Yeah, I mean, we would be arguing for the most minimal
right.
sanction.
Well, of course. When you're talking about the 90-day misdemeanor, 180-day felony speedy trial restrictions, though, if you blow the 90 days or blow the 180 days based on the felonies, you're talking about somebody walking.
Yes, so that's why, well, securing order reform is taking up a lot of the chatter right now. I can absolutely assure people, I can prognosticate that in April or May, there'll be a different round of stories about, I'm not talking about Nassau County necessarily, I'm talking about around the state where things are starting to be dropped.
Understood. Now, we are fortunate in having our own medical examiner's office and having our own crime lab, and we have systems in place. But it seemed as though, based upon the testimony on Monday, that even they were short-staffed for the volume of work that they actually have, and it sounded as though the plans were to add a couple of people here, a couple of people there, but it didn't sound proportionate to the backlog that they had. What do you have any opinions or offer insight to offer as to what we need to be doing with respect to the crime lab and the ME's office to help them get up to speed?
Yeah. Again, those questions are best directed to the ME's office. Mm-hmm. I can only answer that I know, I have heard, I don't know, have firsthand knowledge, that not only the number of staff, but the recruitment for them is also an issue for a different reason. I believe their recruitment is issues of result. Like I think the pay of a forensic scientist is disproportionately low when compared to other job titles. So I've heard in the past and seen in the past that you'll have somebody coming to Nassau to sort of go to the academy here, so to speak, and then they get a very high-paying job at a private lab somewhere else.
No, I appreciate that. And the reason for the question, obviously, we did hear from the ME's office and from the crime lab on Monday. I wanted the perspective of somebody that has a close working relationship with them, but is not inside their office as to what other things we might be able to do to assist in improving. But I appreciate that response. We can certainly follow up. I know we're limited on time.
Yeah, I, from the DA's perspective, we never want to be afraid of burdening the lab. That should not be a fear. We want the accurate, fair, just results. We want as much forensic science as possible. We want to marshal it as quickly as possible. And the danger of even some institutional hesitation of overburdening the lab is a problem.
I appreciate that. Is it still too soon to tell whether we have incidents of individuals not appearing for their appearance tickets? One of the big concerns that was raised, and in fact the appearance tickets sort of adopted the unofficial moniker of disappearance tickets in some cases. Have we seen large numbers of people not appearing for their court appearances at this point, or is it still too soon?
It's too soon to tell for a couple reasons, but the main one is because the disappearance ticket mandates came in on January 1. There was a whole gap where those cases weren't even called until January 20. So you're not talking about 6 weeks of data. You're talking from January 20 to present, which is only about 15. It's not a lot of data.
And with respect to the crime victim advocate bill that the legislature passed, do we know where we are in terms of, we've heard that the county executive is interviewing candidates, I guess, to sort of head the department. Have there been any discussions with the district attorney's office as to how that's actually going to be implemented and how the relationship between the DA's office and the crime victim advocate office is going to develop?
None that I've attended.
Okay. Is that something, I mean, assuming that you have a crime victim advocate in the very near future, to sort of start that department, because we have victims every day that are being subject to these disclosure requirements, without a mechanism to be able to address them necessarily, because obviously the DA's office, even though you are very much concerned about the rights of the victim, you're there to represent the people of the state of New York, not necessarily the victim, right?
We will be seeking justice for all parties, absolutely.
Of course, of course. Are there any plans to start those discussions? There hasn't been any conversation whatsoever.
I'm not privy to them in a sufficient place to even have those discussions yet. Once we have an idea of what the architecture of that department will look like, we'll have those discussions. So the pressing issues for us, of course, that we're handling through our own CVA staff right now is, like I said, the witness protection requests, without divulging too much about what those entail, are double in 1 month what they were last year.
Yes.
There's a lot of relocation and things like that, temporary housing, very big things to coordinate. But also, as I said last time, right now the DA is doing one of 3 parts of crime victim advocacy. The DA touches solved adult crime. The gap in service would be unsolved adult crime, because it wouldn't be forwarded to us for prosecution. That's like, somebody who's had their house vandalized or somebody murdered but not solved yet. So that requires different servicing that the DA wouldn't necessarily see. And the other aspect is solved or unsolved juvenile crime, which would be in the purview of the family court system, which the DA wouldn't have coverage over.
Okay. And my last question is, and it's a topic that was actually raised with Commissioner Ryder, but it has some implications, obviously, with respect to the District Attorney's Office as well. Green light law, for example, has the restriction that we're not able, or that the federal government or federal law enforcement authorities are not able to access, I'll flip that Department of Motor Vehicles, for example, is not able to share information with federal authorities as a result of the green light law. And we have a similar restriction in place precluding us, by agreement, precluding us from sharing information with federal authorities, at least it's my understanding, that's garnered through the Department of Motor Vehicles, if we want to be able to access that information. What is the relationship between the District Attorney's Office and federal authorities like ICE?
You know, that I'm not sufficiently prepared to answer right now. I didn't prep on that, and I'm way too unfamiliar with the subject material to give you any sort of educated comment.
I appreciate that. Thank you for your testimony.
Okay.
Legislator Drucker and then Legislator Verbaum.
Legislator Ford. Jed, Mr. Painter, do you know, well, with respect to the protective orders, at arraignment, is it possible for the DA's office to hand up, when you hand up all your statutory notices at arraignment, can you, at that point, hand up an immediate motion for a protective order, just to start the ball rolling at the outset?
Almost impossible.
Why is that?
Under the case law that's come up, we need to be as particular to that case as possible. Most of the cases you're talking about, which are violent crimes, they were arrested and held overnight. We don't have the benefit of, say, 20 days lead time of a DAT, which means that, you know, because if a violent crime happens at 11:30, somebody's robbed or home broken into, they're locked up at 11:35, and then by 7 o'clock they're on the bus. For the ADA at the arraignment at 10 in the morning to have a fully prepared, customized motion to apply to the court, and if you get that wrong, it just gets bounced back on expedited review, which we've seen happen. It's not good practice of law. It's not practically feasible. It's not going to be legally sustainable.
Yeah, I understand that. Thank you. I'm just trying to conceive of ways that your office could expedite preparing and filing these motions for protective orders for the reasons that we're all concerned about today.
I completely agree, and I think, as I emphasized during my presentation, if there was one thing the prosecutors were clamoring about last year, it was that protective orders are not as easy to get as you think they are. And we were told, you just get a protective order, just get a protective order. We were right. They're not easy to get. And so while I would love a form application, that's not the way the law works. We need particularity.
Okay, great. Thank you. One last question. I just wanted to clarify. Is it fair to say that your objection to the body cameras is the difficult task of gathering all the data, the ancillary data associated with it, and preserving it for evidentiary purposes?
I don't have any objection to body cameras. I think
I'm
body
saying
cameras are
the difficulty of having that for evidentiary purposes under the new statute.
I would say, from the conversations I've had with many police officials across the state, a common refrain is like, well, why would we get body cameras now? It's not for my judgment to say, but I can just only report to you that it seems to be not a laughable notion, but it's just, as far as the undertaking of getting body cameras right now, with what's going on with Discovery being unsettled, I don't see much growth in that enterprise for a while.
See, it's just surprising because I don't think the public knows that. I think the public now feels that, giving law enforcement body cameras is a great idea. It provides for accountability and accuracy and things like that. But,
protects everybody.
And but now, if it's just becoming burdensome, I guess is what you're saying, it becomes burdensome to have it. It becomes burdensome to gather it, to maintain it, and it's kind of an unwitting problem from this statute too.
It is. We would. The burden was not, in a sense, on the DA. We would love body cameras. We love the Freeport Department's use of them, and we download them all or upload them all, and we use them. It's, again, a great investigative tool for lots of reasons. I mean, in a world where everybody can take out an iPhone and record your activity, the officer can't have one hand tied down by recording right back. The body camera allows the officer to have their hands free for a lot of reasons. But the DA would never have an objection to it. It's a matter of whether or not a department wants to take on that individual, if they find it to be a burden. So you'd have to, I'm sure, if you called in 25 different police commanders right now, they might give you 25 different answers. But all I can tell you is, with everything going on in the cultural moment, I don't think it's going to be a growth enterprise.
Thank you very much for your presentation today.
Thank you so much for sharing with us the wealth of information that you have about the workings of the District Attorney's Office. I know it's been enlightening to most of us, if not all of us and everybody here. A few things I would just like some clarification on. When you were talking about the backlog and discovery, I want to know, how does the Early Case Assessment Bureau play a role in that?
Okay, so Early Case Assessment has now 2 physical locations. We've put in our intake operations, Early Case Assessment and arraignments are linked. So you're going to have some data entry at the police headquarters hub, and you're going to have finish off at 99 Main, because we're going to be keeping on working on the intake and discovery compliance processes all the way through the point of arraignment, and even sometimes after the arraignment. That's where all the initial witness contacts are, you're caught on the phone. That's where 24 hours a day, when the police make an arrest and they ship the paperwork to the DA's office, we will receive it electronically. We will put their case management records into our case management system. If it's big file sizes, besides the direct share capabilities, we have lateral, what you would call drop boxes for larger files. And we've worked out these protocols with now every single police agency that does business in Nassau County. So basically, if they get an arrest, they will call, they will notify ECAB of the arrest. ECAB will say, great, send us everything, because nowadays it's send everything. If they have any trouble or there's any questions, to ask the officer right then and there. They will ask the officer right then and there. They'll take down, what statements did they make, what kind of property was recovered, is there surveillance video from Target? Can you get that surveillance from Target, or do we have to go out and send somebody out later? So we staged the case right then and there, so we have the best possible package within 24 hours of arrest. That having been said, not everything on the discovery end is capable of being recovered within 24 hours of arrest. There will be lots of things that go down, like radio transmissions, GPS data, memo books of associated officers. Because remember, you're talking to one officer, not the whole 8-person crew who was at the scene. So, and they're not going to hold all 8 to talk to ECAB and exchange discovery with ECAB that night. So there might be, you get something from one, but you still have to hunt down 7 more. But that's generally what happens. And that communication will happen. We'll find out witnesses' names, victims' names, reach out to them, see how they're doing. How have you been? You've been through a traumatic experience. We'll get information from them. Maybe they have a home surveillance system, so we will get to work on that as well. The function of ECAB used to be one of assessing things for legal sufficiency. We wanted to make sure the charges were good for filing.
Right.
Now, I got to tell you, it's such an ancillary function. Now the main thing is acquisition. It's about acquisition and induction into our case management system so they can be prepared for electronic discovery as soon as possible. We at the DA's office would like to send, ideally, an initial package, and we have been, to the defendants within 15 days. Whatever we have, it could be complete, it could be not complete, but whatever we have, we're going to send to them in 15 days, and then we'll try to work within the extension period if we need it. And a lot of that comes from ECAB.
Okay, thank you. You also mentioned that there's a problem with ballistics and forensics. You said ballistics, it's very hard to
We don't have
get
any
information.
forensic examiners. That's a dearth of forensic examinations. And we had been outsourcing some of those responsibilities, and those who we outsourced to are now also experiencing the same dearth. So gun crimes and anything that requires ballistic evidence is in serious jeopardy, not through any fault of what the DA is doing, just that's system shock. It was in trouble before this. It's now in severe trouble.
Okay, and lastly, it's very upsetting to hear about the lack of morale and what's happening with the ADAs, and in particular, you talked about the paid family leave policy.
Yes.
Now, is it the same policy that all Nassau County employees have?
No, I'm not aware. I'm saying Nassau County has not taken a step forward in this regard, and I would encourage, because this is where I am, I would encourage that you look hard to, it is the 21st century, and New York City is a major recruitment competitor for at least my department, and there is no reason for my department not to do it, because my department is 45% of the exempts. The exempts, I'm aware, have that termination pay cap of 30 days. We, just like every other department, gets salary end to end. So no matter what is happening during the course of the year, sickness or whatever, we always have budgeted for somebody's full year salaries if they took every single day. Where the budgetary impact of any sort of paid leave comes into play is twofold. Managerial, can I afford to lose somebody for 12 weeks, which is the DA absolutely, for child leave, of course. And the second one is, are you inflating, perhaps, their termination package? Because if they don't take the 12 weeks in a year, then hypothetically 4 years down the road, if they decide to leave the DA's office, they'll have 12 weeks of time waiting for them because they didn't have to take vacation and personal. They wouldn't have drawn down from their bank of time. But because, specific to exempts, this legislative body capped us at 30 days after 2019, there's no possibility of them banking the 12 weeks. There's no possibility of doing it. So you run almost no financial risk from just saying, okay, for the DA's office, you can have paid child leave. It is a major, major, major recruitment issue. Again, New York City's minimum is 6 weeks, and many of the offices of Manhattan, Brooklyn, they're 12 weeks.
Yeah, I just thought last year that the state made, I thought, more liberal paid family leave possible for the counties, and I thought there was a change.
We
There-
do
no
not
change?
have it, and we really could use it, because I think you saw the statistics I flashed on
Yeah.
the screen about our percentage of staff, mostly female, majority female, and majority of that female cohort being between ages 24 and 35.
Okay, thank you.
We just have two more
Sure.
legislators, Legislator McKevitt and then Legislator Bino.
Could you just explain the significance of March 8th as far as the marijuana testing is concerned?
Yes. 1 second. I can be very specific.
I mean, I'm just curious as to why that date is you already have it earmarked out.
That's the effective date of the legislation. Just give me 1 second, if you don't mind. I'll just, okay. There were changes to Public Health Law 3302. The definition of marijuana in 3302 underwent a significant change and included a definition for hemp, cannabinoid hemp, and hemp extract. As of March 8th, marijuana shall not include hemp. I'll spare you. Basically, shall not include hemp. And essentially, in order to differentiate marijuana from hemp, the sample must now have a THC content greater than 0.3%. Current laboratory procedure is qualitative and can thus only identify the presence of cannabis sativa plant in addition to the presence of THC. It cannot quantitative to determine whether or not the THC content present is greater than 0.3%. So as of March 8th, not our lab, all labs will not be able to differentiate between marijuana and hemp and cannot conclusively identify one over the other. There are DEA-validated technologies available, but they will not be able to be deployed in Nassau County until September 2020. So what I said was there will be a gap in practical enforcement of any marijuana at least between March and September.
Okay, thank you.
Okay.
Thank you, Madam Chair. Hi, 88 Painter, how are you?
I'm well, thank you.
Good. I wrote down two questions at the very start of your presentation. So I'll start with the body cams, because I know you'd already been speaking about those with Legislator Drucker. Could you explain the metadata? Because that, I understand that to be the encumbrance of, that's what you're concerned about, that would be delaying?
Again, I have no concerns.
No, you listed it as a...
Yeah, I'm saying with in New York City, I believe it was out of Manhattan, there was a lower case law discovery decision that said, in addition to turning over the body cams of the NYPD, they also had to turn over the metadata, which was one example of some things that ADAs are going through over in that neck of the woods. It's not binding on us yet, but if those trends continue, that it's not just, sending a video from like one iPhone to the next, think of it that way, is easy. If you have to then all of a sudden download the whole phone to hand it to the next, it's a little bit differently. We would be texting a lot less often if that were the case for every single transmission of video or photo. Even before that, though, the storage costs of body cams and the preservation, it's a phenomenal expense. I think some people get confused when they think about, we even had a presentation on resolutions. There is a chart that will show you that if you're recording something in, say, 480p.
I'm sorry, but I'm trying to understand the link between the discussion about body cams in your presentation to bail reform.
It's not bail reform.
I mean,
yeah.
discovery, sorry.
Yeah.
certifying discovery. You
Yeah.
indicated that it was actually the metadata, when you have to provide the metadata, that it then kind of slowed down the process
Yeah,
for being able to meet the timeframes.
Yeah, oh, absolutely.
So if you could explain
if
what
NYPD
metadata is for me, because I really don't know what that is.
Again, when you take a photo with a phone, I'm just trying to put it if you take a photo with a phone, the photo is what everybody sees, but your phone knows when it was taken, where it was taken. You usually have geographical data. It might have other data in there that can link that photo with other faces in your photo album. That's why your iPhone can curate and put all the faces together. So it's that background encoding on the image that travels with the image that, so that's one photo. So the
But
body
that
cams might
data
have the
does
same.
travel with the image, or it doesn't? So you have to do a separate
Not
download?
necessarily. So yeah, so there could be a separate download. So if the body camera, disclosure was just a video, that's one thing, which has its own things. If all of a sudden now you have to go to the corporation and get the metadata as well to travel with the video, and now you've not only increased the burden of collection, but you've also increased the amount of storage. All these files are gigabytes upon gigabytes.
And it's a very complicated process to download this metadata that slows it down that
I'd be
much?
speculating corporation to corporation. I'd be speculating because there's various different vendors of
Okay,
body
so
cams.
in the case that you were referencing, that you just stated just earlier during our discussion, and you referenced in New York City, how long, do you have any understanding of how long it delayed the process?
No, I'll have to reach out to my colleagues in Manhattan for that. We don't have the same issue because we only have Freeport here who has body cameras. We have not experienced that issue.
Okay. All right, and then so we also talked about the crime labs and a whole bunch of other stuff during your presentation, and we had a presentation here at the legislature just this past Monday about the significant time that is required to give, the results of certain testing. And so, and then there's a whole bunch of other discovery items that have to be compiled and then submitted and certified, right? And so we're saying 15 days, the initial 15 days is not reasonable. And then we're stating that you can get, it's my understanding, you can get a 15-day extension.
30-day.
It's a 30-day extension, so now we're at
15 to 45.
to 45.
Yeah.
And if that's still not enough, then in your opinion, could you tell me what we should be, lobbying for, advocating for in terms of an appropriate time frame
Yeah.
to be able to extend that period, to be able to really be able to certify discovery and be within compliance?
Yes. So again, I don't want to reach the simplest solutions because, as I put in my slides, timing versus content. Where I'm much more troubled by content. When I say I'm much more troubled, like the office is much more burdened by content versus the timing. So it's saying like you're extending from 15 to 45 days is standard. Okay, but that does not help with the acquisition issues of still these various ports. The 15 to 45 has some diverse opinions in Nassau County Court so far. Sometimes it's automatically granted. Other times judges have said, no, you have to apply for it. It's not automatically granted. So we even have different distinctions of how you actually get that extension. We have some people invoking it, some people applying for it. But after the 45 days has run, you could theoretically file a motion for greater extension of time. That might even have some different legal interpretations. We'll see what that happens, as far as the validity of a motion to extend time, or you just eat the sanctions. Why extension of time on its own is not necessarily a solution is because they did not co-equally amend speedy trial. So I'll say it in a different way. 45 days, let's pretend that's the standard on a misdemeanor case, that I need 45 days to get something together. By the time I have to certify before I can be ready for trial. So if I certify by day 45 and state ready for trial, I've burned half of my speedy trial clock anyway, and the biggest sanction is the case being thrown out. So if you said, oh, we'll give you an extension to 90 days, I'd say, well, thank you, but really I'm going to certify and the case is going to get tossed. So until speedy trial is co-equally extended, or discovery excluded from speedy trial calculations. The extensions don't really make prosecutors more at ease. The big stress is the case getting thrown out.
So speedy trial would need to be amended.
Co-equally amended in some way.
I know that our DA is in conversations or with the state senate, or there was some committee that was put together that was going to talk about some of these reforms.
Yeah.
And so I hope that that is part of the discussion.
I don't want to overstate any of my
I'm not
office's
asking you to.
role. No.
This is a statement more than a question.
But as far as a committee, my boss is not on any committee.
She's not?
And has
I
not.
understood that there was,
There-
is there a regional? No, so let me change that. It may not be with the Senate.
So that's why
It's
I'm-
regional here between Nassau and Suffolk?
I am not aware of any committee that my boss is on right now. Okay? Nor am I aware of any legislative draft that my boss has reviewed.
I thought there was a task force set up. I thought it was for bail reform. Maybe I missed. Was it bail reform? Okay, I'm sorry. I thought it was for the bail reform.
So I just want to make sure
Okay.
that my boss is not on any committee that I'm aware of, nor
So
has she
there's no
seen any
committee that's set
legislative
up at all to
drafts.
start talking about this locally, regionally, between our local police departments and our
I am
I would even
aware that
extend it
people.
to say the DA's office, and we should have something, I would suspect, then started.
I am
start that
aware of
conversation.
people calling my boss
As well
for
as
input.
legal aid.
Calling my boss
we're
for
gonna get this-
input. My boss, to my knowledge, has
Okay,
not
I've
joined
heard
any
you and I
committee.
understand
or,
that. I heard you and I understand that.
Okay.
I
just want to make sure the record was clear on
There's
that.
so many task forces
Yeah.
being created across this region, but this would definitely be one of those times where I think we get the right people in the room to start talking if we're going to be advocating for some level of change, that we have legal aid should be in there. We should have our prosecutors and our police departments and some other advocates that are looking to make sure that we're not unnecessarily holding the wrong, holding folks that ideally should be released, and that we're holding folks that should be held.
Perhaps the confusion, if I may.
Mm-hmm.
My boss, D.A. Singhas, does sit on the Justice Task Force, the New York State Justice Task Force, and that is a consortium of academics and defense attorneys and prosecutors and police officials and victims advocates, and they meet and discuss issues. In fact, a meeting was this morning, but they issued the
No.
report on bail. They issued the report on bail in February 2019.
So I have to give a shout out to my staffer, Andrew. He must be listening somewhere. He actually just sent me something from January 21st. It says Nassau and Suffolk counties team up for common sense bail reforms. All right, so I'm going to read through this, and then I don't want to do it while I'm on
Okay.
taking up time. I believe public has an opportunity to speak after me, but I'll look through this. Thank you.
Thank you.
Thank you very much. I really appreciate your patience and your answering all these questions, and actually even starting this out with the positive spin.
Yes.
I think it was really good, and we want to partner with you to make sure that we heed the concerns that you have, especially with maternity and whatever. So, you're doing a yeoman's job, and we appreciate it. So we want to make sure that we show appropriate respect.
I'll end with a positive spin. We're going to get through this, and I think everybody's going to be a lot happier in 3 years. Hopefully we can look back and say, look at all the preparation we did and all the improvements we made. There will be some bumps along the way, but my biggest concern right now, and my boss's biggest concern right now, is the morale of our staff, because we want to make sure that we have the right people in the room working through these issues.
Well, I think they're very thankful that they have you. And DA Madeline Singhas, I have to say, too. Good.
Thank you very much.
All right, thank you. All right, Mayor Kennedy, if you still, okay. And everyone in the audience, thank you for your patience as we went through all these questions. Good afternoon.
Good afternoon. How are you? Thank you for having me here today. If I could just start by saying my name is Robert Kennedy. I'm the president of the U.S. Conference, New York State Conference of Mayors, consisting of about 700 cities and villages throughout New York. I'm also the mayor of the village of Freeport. NICOM is here to discuss specifically the discovery aspect of this legislation only. In fact, we haven't taken a stand on the bail portion at all, but do recognize some changes are required. I am not an attorney, but I have had in-length conversations with our village attorneys and state attorneys with regards to the discovery package. I would just like to say a little background. The village of Freeport has approximately 1,100 arrests a year. Out of those 1,100 arrests a year, we would be required to provide about 50 sets of discovery because the DA would probably plea bargain most of the cases down and come back to us and ask us for 50 cases. Now, with the terminology used in the legislation, which says accusatory instrument, the village of Freeport would then now be required to provide discovery on 6,500 building department violations, including the electric violations, plumbing violations, water, structural, even a dog violation. If it was issued a violation, we would have to provide discovery. In addition to 20,000 vehicle and traffic regulations and 35,000 parking tickets. That's the addition now of about 52,000 discoveries that we're required to provide because there is an accusatory instrument involved here. This has been discussed through NICOM. It's also been discussed with Mayor de Blasio, who didn't understand it at first, who agrees with me now that the way the law was written, these issues are a problem. The village of Freeport does discovery. Now, you know that the village is the first one in New York State to mandate the use of body cameras. Every police officer in the village of Freeport who is out in the field wears a body camera. So picture you have 9 police officers on an emergency crime scene, and then they're taken from that crime scene, possibly gone to a family dispute or maybe an automobile accident. And then they come back, and then they're sent out to direct traffic, and then they come back. Picture now these 9 or 10 officers, every body cam that was uploaded into the cloud, which cost monumental amounts compared to what it did 4 years ago. We have to pay somebody to sit there, and it has to be a police officer, to go back through that cloud and deduct every portion of those police officers' time attributed to that crime, which is a significant amount of time considering a crime act may be there for an hour or two and you have 10 different officers. So by having these body cameras, it really increases the time for discovery to be provided. We also have memo books on every police officer, radio communications from every police officer to police officer, from the desk to the police officer. We have 911 requirements for discovery. We don't get 911 calls. 911 goes to the county, and then the county will call the village. So we don't have a record of the 911, but we have to secure that from the county. We also have LPR program, which many of you are familiar with, where we surrounded the village with license plate readers. So every one of those LPR cameras are going to have to be downloaded out of the computer relating to this crime and then stored again with the discovery package. Then when you're working with different agencies, Nassau County or the state, we have a lot of state police and bringing all of those together for discovery. It does not take 5 minutes to do one discovery, and if we're increasing the load from 50 to almost 40 to 50,000, it's a significant more amount of time required. Our budget is due in February. Last year, this law was enacted in May. So when we adopted our budget, we had no idea that this legislation in New York State would affect our budget. So we last year built in with a $1 million hole in our budget because the state adopted this after we adopted our budget. This year we have the time to look into it and estimate what our costs are going to be. And realistically, I have to look at worst case scenarios. Worst case scenarios for me, we estimated $2.7 million. $2.7 million. Now, I just want to go back to give you a little background on Freeport. We're rebuilding from Superstorm Sandy. 3,500 homes under 6 feet of salt water. We lost the entire industrial park, $10 million to the Department of Public Works. the entire nautical mile. We've rebuilt probably 96% of Freeport since Superstorm Sandy. But we had a reserve at that time of $1.2 million. We now have a reserve of $21 million. We had a debt of $160 million. We now have a debt of $92 million. We got upgraded by Moody's twice over the past 6 years. We put on 25 additional police officers and reduced crime by 56% in the village of Freeport. We've done 86 roads. We absorbed every increase in workman's comp, liability, disability, medical, retirement, PBA labor increases, and CSEA labor increases. And we haven't had a tax increase in 6 years. There's not much money left in the village of Freeport to absorb a $2.7 million unfunded mandate, which we've just incurred. We've increased taxes by 5.7% this year in its budget already. First time we pierced the cap and increased the budget by $2.7 million for the residents of Freeport. It's directly attributed to the cost of the discovery. This legislation was put into a budget without having been properly analyzed or reviewed by the various police department or district attorneys throughout the state. And now what we've done, we're steering the horse by the tail, trying to find out what we can do to correct this legislation that was done. Ultimately, we have to eliminate the inclusion of vehicle and traffic laws, building department violations, and parking violations. There's no reason for that, and I don't think that was the initial intent of this law. And I think if you were to provide 60 days, we'd probably go down as low as 30 days for discovery, since the individual is not incarcerated anyway. That's why we're doing these desk appearance tickets. If they're not incarcerated, give me 30 to 60 days on discovery. We could save the village of Freeport residents $2.7 million. We've been told that the village will save money because we're not incarcerating the individuals. We'll save on the cost. We don't incarcerate individuals. We take our prisoners to Nassau County. We're not saving anything. If Nassau County releases them, it doesn't give me any benefit. I don't get released. My taxes aren't lowered by Nassau County. There's no benefit to the village of Freeport. We haven't had an increase in AIM funding, CHIPS funding, snow removal, or sales tax in 11 years. And please don't even remind me about sales tax, because we don't get it to start with. I'm in litigation about that. All I can say is this is an unreasonable, unfunded mandate to the residents of the village of Freeport and the rest of the residents in New York State. And that's on behalf of the New York State Conference of Mayors. I'll be glad to answer any questions.
Legislator Millay?
Yes, thank you. Mayor, you are my mayor, and I was also on the Board of Trustees prior to taking this position, and so I know that everything you're saying is absolutely true. And I think it's important that we do understand the implications of this state law on not just the county, but also the villages and the cities, because again, this is a state law, and it's important for the representatives of the state to have a full understanding of this, and this is, I guess, one more avenue for that to happen. When we first heard about the law, when we were doing the budgetary, and we all, of course, had concerns about it, one of the first things I did was go to my state legislators, and I think it certainly behooves all of us to speak out, and you bring up some important points that perhaps we wouldn't have considered prior to that. So I thank you for your advocacy on behalf of the other jurisdictions.
Thank you, and we miss you in Freeport. Come on back.
Legislator Rhodes?
No, thank you, Legislator Ford. Mayor, first off, thank you for coming today. I appreciate your presentation very much. And as Legislator Millet indicated, the reality is that this just does not have to do with with Nassau County and the Nassau County Police Department. Every village, every township that actually processes building department violations has to deal with the same issues with respect to discovery, and I appreciate you raising that important topic. Just to give us an idea, and I know you mentioned and you mentioned body cameras, and the Village of Freeport is the first to implement body cameras with its police officers. Can you describe for us you heard the testimony of the police commissioner, Pat Ryder, and of Jed Painter as well from the district attorney's office, speaking about metadata. Can you go into what's involved in actually maintaining the data that comes from the body cameras, preserving that? What are the challenges with that, and what are the costs associated with that to a municipality like the Incorporated Village of Freeport?
You know, first I would like to thank Nassau County and especially DA's office who provided financing for the first order of body cameras that we utilized in the village. But this is going back 3 and 4 years, and there's been upgraded models since. There's battery damages, there's equipment damages. So we've really upgraded our equipment 2 or 3 times at the cost of the Village of Freeport taxpayers. As I said, the original purchase was great, but now to maintain it. And when you store all of this equipment, I mean, we can't even store all of this on site, so we have to store some on site, and we have to back it up off site. And we have to have enough data availability. This digital is astronomical when you look at the location, the detailed cameras, lighting and such like that. It's tremendous, the financial burden we have for storage, on-site, off-site, and then to have to, again, transpose all of this into a criminal case for discovery.
So we can comprehend what would have to be turned over out of that body camera footage. Yeah, I know you gave the example of a police officer responding to the scene of a crime, but then getting diverted to different calls, having to leave the scene, come back. What would actually have to be turned over?
Well, we have to have a supervisor go through every one of those police officers' body cams that were in attendance there, and then take out any applicable video applied to that case and remove anything else. If you went to a call for a family dispute or another arrest, or if there was a car accident or a bodily injury, all of those, because he'd be using body camera doing all of that, that would all have to be deducted out and limit the individual videos to pertaining to that case itself.
And so if you had 10 officers responding to the scene of a multi-vehicle accident, let's say, where there was a DWI, you would wind up having to preserve and then turn over the body camera footage for every one of the 10 responding officers.
Yes, and it could take approximately, between 4 and 5 to 6 hours to take it all apart and provide the proper discovery package. And remember, that's not just the body cameras. You have cameras in every police car. So every one of those police car cameras, it's uploaded to the cloud and it has to be taken out. So it's quite time-consuming and a financial burden to the village to do that many in that shorter period of time.
Now, have you had to increase staff as a result?
Yes, we have, and unfortunately, the staff becomes another issue because I can't hire civilians, and I have to hire through civil service, and then by the time you can hire through civil service and review them, and they have a preference for village employees, and then send them back to civil service for approval, then go through an academy and come back to be able to move people up the ladder. It's time consuming. It's very, very expensive.
I can only imagine. Now, I know that you indicated that the short-term budget costs may, through the conclusion of your fiscal year, were somewhere in the area of around $1 million that came as a sudden and unexpected hit on your budget.
Yes, we probably would have had $1 million surplus this year. Now we have a flat budget for last year.
And it's now resulted in a 5.7% tax increase just for the $2.7 million that you now have to raise that's approximated it will cost the village to comply with criminal justice reform.
That's correct, and I would just like to clarify, the village can have an increased budget every year, but it doesn't mean the tax levy has gone up. Because if we bring in more revenue that's not a levy, that can compensate for a larger budget. In fact, this year, because of the additional economic development we had, we probably would have had a 1% reduction in the levy in the village. But based on the mandated increase here, we're up at 5.7% increase.
So in reality, it's a 6.7 percent increase when you factor in that it probably would have been a 1% tax cut. Now, obviously, this was presented as a sudden and unexpected challenge. Now you're trying to anticipate your needs for the next year now that you have had a chance to see what some of the results are. But that $2.7 million is just an approximate.
Well, you know, I have to say that we consider the worst case scenario. We hope we're correct. But a village is not allowed. It's against the law for a village to run a deficit. Many cities, counties, and the state can run a deficit. It's against the law for a village to run a deficit. So therefore, I had to be extra sure that we have enough prosecutors, we have enough backup in the buildings department, we have enough backup in the parking portion of the village, staff, judges. We've applied for, we're only allowed to have 2 judges, 1 full-time, 1 is appointed. So now we need a 3rd judge, a part-time judge. So I went to New York State to request approval for a 3rd part-time judge. We're the 2nd most active courtroom in New York State.
Now,
so I really can't, you know, it's the elasticity of demand. You can't stretch it any further. We had a court the other day. It went for 7 hours. It was the largest continuous night for court cases that we've had so far.
Wow. And I was going to ask, have you seen any increase in the volume of work that your judges and your courts have to
Yes, and again, this was retroactive. As of January of this year, any outstanding cases from before required the discovery to be prepared. So there's a lot of work that wasn't estimated that's now included in this year's budget that we had to work on prior to January 1 this year.
And I did not know, and I appreciate you for raising, I did not know that that included building department violations and that included traffic infractions as well.
6,000 minimum, 6,000 building department, 20,000 vehicle and traffic, and parking tickets. So if you plead not guilty on a parking ticket, I have to provide discovery.
Now, I think I know the answer because I've asked this question a few different times to different witnesses, and the answers seem to be the same. I'm assuming that the Incorporated Village of Freeport, certainly yourself as head of the New York Conference of Mayors, were not consulted at any point in time during the pendency of this cashless bail reform and criminal justice reform before it was passed in Albany, correct?
That's correct. In fact, I've subsequently, after learning it, I called together all the chiefs of the police departments in Nassau County, many of the mayors. I called NICOM to sit and review this with them. And Mr. Painter I sat with just to review all of the reality of the impact of this legislation to come in. And we did discuss parking tickets. We did discuss vehicle traffic. We did discuss, accusatory instruments, because we had to make sure what we were anticipating in doing our budget. And again, my budget, I had to adopt the budget in January this year for next year. So I don't have the liberty of waiting till after the state adopts their budget and possibly makes a change.
And of course, I'm assuming that this mandate from the state is unfunded to the village, correct?
That's correct.
So even though you're going to spend $2.7 million this year, you expect to comply with this, has there been any indication from any of our state legislators, and I believe we're covered in the Village of Freeport by Senator Kaminsky, Senator Brooks, any indication of any assistance coming from the state to help local municipalities who can't run a deficit, as you've indicated, to provide any assistance?
I'm cautiously optimistic. I've been up in Albany for 4 days. I've been with at least 6 or 7 senators, many representatives in the Assembly, and I think after discussing all of the facts, I'm cautiously optimistic that some changes will come to fruition, and I would hope that it's in the next budget, so that that's not an item that can be debated. Put it in the budget, let's get it over with, and make these corrections now. I'm also concerned with, cannabis. I mean, if we follow the same path that we did with the discovery, without seeing the rippling and the effects of this, and you put the cannabis into a budget and approve it, are we going to be back here next year discussing all of the problems that we have that we didn't anticipate was the legalization of cannabis. And I think, again, we need to spend more time before we legislate or adopt these legislations.
And has
items.
anyone reached out to you from the state with regard to that, to discuss the topic?
I mean, yes, I've been up and I've been discussing it with all our representatives, the Senate, the governor's office, one of his representatives, the budget director, and some of our assembly people up there.
Has there been any indication that it's going to be considered as standalone legislation as opposed to what happened with criminal justice reform, where it was sort of wedged into the budget and there really was no opportunity for debate or discussion?
I can't really answer that question. That's the Assembly and the Senate and the governor's office.
Of course, of course. Just if you can educate me, with respect to the Nassau County Medical Examiners and the Nassau County Crime Lab, how does the Village of Freeport and the Village of Freeport Police Department rely upon RME and our crime lab? What activities are performed by the village, and what do they rely upon our crime lab to do?
Our law enforcement, Nassau County's law enforcement, work very close together. The felonies are generally taken by Nassau County, so they would be responsible for the crime lab or analysis of scientific evidence.
Have you seen any increase in delays that you attribute to increased volume from criminal justice reform in terms of processing items for the village through our crime lab?
That I can't answer.
Too soon to tell?
Yes.
Okay. And just in terms of, because obviously you have many hats, one of which is president of the New York Conference of Mayors. Have you heard feedback from other mayors throughout the state?
Oh, yes.
Are they facing similar challenges to you?
Absolutely. We have probably several million residents and representatives petitions out there opposing the discovery portion of this legislation.
Okay. And can you speak to the crime rate in the incorporated village? I know there had been a steady decline, over 50%, I believe you had indicated over the last several years. Since January 1st, has there been any change in that rate?
That I don't have the results in yet. Normally we get every month I'll get a preliminary report, but it is confirmed that we've had a 56% reduction in crime over the past 6 years. And we believe it's attributed to the LPR program, to the additional police that are out there.
And that's the license plate readers, right?
Yes.
Just for those that are listening that don't know what LPR is.
Yes.
Okay. Mr. Mayor, I appreciate your time and your testimony. Thank you so much for your insight.
Thank you for having me here.
Thank you very much for your testimony. You really gave us a lot of information, a lot of things that we didn't even consider.
Right.
But my last question to you, sir, will be this. Would you ever consider coming to run the city of Long Beach?
That's a great city. I love it.
So do I. But thank you very much.
Thank you so much, everybody, for having me here today. I greatly appreciate it. Have a great day. Thank you.
Frank, do you need a break at all? You do. We're going to just take a 5-minute break or a 10-minute break, okay? Good afternoon. We're going to resume our hearings, and I'd like to know if Brian Sullivan, President of Cooper, is here or not. Even with my glasses, I do. Okay. Oh, okay.
That was a true 5 minutes, huh?
That's because I want to get
Good afternoon, ladies and gentlemen. Oh, sorry. Got to get the most important guy in the room. Good afternoon again, ladies and gentlemen. Brian Sullivan, Nassau County Correctional Officers Benevolent Association. It was a much more full room before. Legislator Rhodes asked a question earlier about the head count in the Nassau County Jail. Just to clarify, I got some information. As of November 1st, 2019, the inmate head count in the jail was at an all-time low of 1,115. That was the lowest in my 31-year career, 1,115. Normally, it would be around 1,600. The bulk of my career, I was here when it was the worst. When I first started in 1988, was when crack and AIDS was big. I've said that before here several times. The head count in a much smaller jail was over 2,000. It's been around 1,600 to 1,800, but over the last several years, because of all things I've talked about here before with the precursors to bail reform, our head count has been dropping precipitously, and November 1st it was 1,115. As of today, our total inmate head count is 759. That's a reduction of 356 inmates, the rolling tally in the jail since November 1st. That is a startling number of people that have left our facility, that have left the system. Like I said, I've been here countless times before over the last few years, warning of what's been going on in New York State, both here and in Albany, talking about what's been going on, particularly at arraignment courts. I'm sure everybody remembers that I've been talking about how we've been letting people go on heavy-duty drug charges, assault charges, robbery charges and burglary charges. This stuff has all been going on for several years. That brought our head count down to, like I said, 1,115. This was prior to what went on here in the last year with bail reform. People that can get out have gotten out, and now we've just gone precipitously over the edge. Myself and countless other law enforcement organizations have been pounding the floors in Albany and here, obviously, since we realized last year what was being done under the cover of last year's budget. One or two of the legislators said earlier that a lot wasn't done here, and a lot of people didn't really know what was going on, and that's true, because even some of our local law enforcement unions, the police department and the DA's office and things like that, didn't realize what was going on. We noticed it from our end of the criminal justice system in corrections and in the courts and the judges and things like that. We saw the writing on the wall of what's been happening here, that they just don't want people in jail anymore. I had a couple of different notes here that I want to make sure of. Going back to the hearings of last year, there were no public hearings. Again, the stakeholders were not involved in this. Police organizations, sheriffs, police chiefs organizations, unions, nobody was involved in this. This was all done behind closed doors. Nobody saw what was going on until there was a product put out. We saw what was happening, and I have certainly annoyed, PO'd a lot of our local state legislators because I've been exposing the hypocrisy of what's been going on here. Since this debacle was put in place, I've been a very vocal opponent of this. Let me get my glasses on. That would certainly help. Like I said, our local New York State senators, particularly on the Democratic side, are not very happy with me because I've been exposing the hypocrisy, particularly that this has created a public safety crisis problem, not just in general, the general public, but more so in high crime and low income neighborhoods, communities. The very communities that these advocates for these bail reforms are claiming to be advocates of. And Monica Martinez, who is a senator out in Suffolk County, I've had numerous conversations with her where she has actually spoken about how these bail reforms and discovery reforms are going to affect her neighborhoods and her communities the worst. Of course, you know, she was one of the ones that signed on and voted for this, because the way everything goes on in Albany is if you want your school district money and you want things for whatever, you're going to vote yes for the budget. So everybody kind of had a gun put to their heads. Meanwhile, you know, I'll give her some credit now. She has been a vocal critic of bail reform and discovery reform, and has been behind the scenes trying to get things changed. As far as I think she's annoying the master's voice up in Albany also, because there's a lot of infighting going on there. The only community that these bail reforms and discovery reforms are advocating for is the criminal community. Jed Painter spoke before about drugs and what do you call it, the diversion courts, things like that. That's 100% correct. They're not even being diverted to diversion courts. And in the Nassau County Jail, where we have detox programs and drug programs, they're not being able to avail themselves of this. So what goes on is you have people that are arrested for crimes that are either high on drugs or they're selling drugs. They're addicts. They're not being put into programs. They're not being put into diversion programs. They're not being held in our jail. They're not being detoxed. They're not being put into drug rehabilitation programs to help them that are coming from a lot of these low-income and crime-ridden communities. They're being kicked back out into the street again. And what are they going to do with the first thing to get back out in the street again? They're still addicted. They're going to be looking for the next high. They're going to be committing another crime. I've said that numerous times. In conjunction with several of you here and other organizations, including the Downstate Correction Coalition, we've been on an informational tour educating our residents on exactly what has gone on in New York State, completely under the radar until it was implemented last year. Going back to 2013, one of the things that I key on is a lot of people aren't familiar with the Lippman Commission. Jonathan Lippman, who used to be the head judge in New York State, the New York City Council put together the Lippman Commission to study criminal justice reforms in New York State, and with the laughable premise at that time of how do we close Rikers Island. Rikers Island had 15,000 inmates on it at the time. The idea was, how do we close Rikers Island? Where exactly were all of those prisoners going to be going? I also have spoken numerous times about the myth of mass incarceration. I know a lot of people have been talking about this. The United States has so many people incarcerated. Over the last 10 years, the incarceration rate in the United States has dropped precipitously. There is no mass incarceration anymore in this country. Just talking, and especially in the state, just talking about the numbers that I've had before. Our inmate head count just in Nassau County, our own local community here, should be between 1,600, 1,800 inmates. It's down to less than 1,200, 1,150. It was 1,050 before bail reform, and then we ended up losing another 350. Also the fact that prior to bail reform, over 70% of all people that were arrested in New York State prior to these reforms were either released on their own recognizance or bailed out. 70%. That left 30% of all people that were arrested for crimes in New York State under the discretion of a judge, who, even at that point, there was no judicial discretion about public safety, but there was a lot of other avenues the judges could have. One thing that I could say without a doubt, from my perspective, and I know a lot of other people probably won't bring it up, is that there's a lot of agendas at play here. Money, real estate. They had on the Lippman Commission, there was 27 different people on it. I believe it's 14 people that were on that are in law firms that their specialty is real estate. These are the people that were on the Criminal Justice Reform Commission in New York City about what to do at Rikers Island, and more than half of them were real estate law firms. If that's not eye-opening to a lot of people, I don't know what is. The other part of it is not wanting to pay the cost of incarceration for municipalities. And now, if you speak up against these reforms and against the fact that these things were shoved down everybody's throats, you're a racist. You're a fearmonger, because they just cannot accept the fact that there is a true public safety crisis going on in New York State. So you're a fearmonger. You're a racist, thinking they're going to shut people up. You're not shutting people up when every single day, even on this, pardon my language, this liberal rag, the Daily News, is talking about a menace to society who should be in jail. If this is on the front page of the Daily News, imagine what's really going on. That's probably about as left as you get. Just a couple more quick things. I've been here before, and that heart-wrenching thing that we got this morning from Mr. Maldonado. He went through the list of crimes and all of that. I'm not going to go through it again. You've all seen this, 4 pages of all the crimes that are absurdly not under bail reform. The heart-wrenching story, I mean, that speaks for itself. I don't know what else you could possibly add to that. Today and every day at arraignment court, people are released, criminals are released for every manner of crime. I follow the statistics. I have it in my office. People are being released for strangulation charges, for heavy-duty A and B and C felony drug charges, all kinds of assaults, weapons charges, the whole 9 yards. Jed Painter talked about the Brooklyn DA's office, that they had 40 people quitting because of they were just completely overburdened and they can't get anything done. Cy Vance in the city, the DA in the city, is talking about how they're just not going to prosecute crimes because they can't keep up with it. That's insanity. How does anybody, not even advocates of this, see that that's a problem? Again, we talked about it several times before. No funding was included in any of this from the state. These are all unfunded mandates. No training, no guidance on monitoring. The people that do get ankle bracelets, there's no restrictions on their locations. They're not restricted to their homes. They could travel all around the world and cut the bracelet off, and nobody cares. Drug felonies I talked about, they can't issue bench warrants for 48 hours, no judicial discretion. I've talked about this several times, where is the constitutionality? One judge up in Cohoes, I believe, brought it up about the constitutionality of the separation of powers in the state, judicial, legislative, and executive. How does the legislature take away the powers of one of the other branches of government? It's insane to me. Dave McAndrews is a district court judge in Nassau County, in Hempstead. He spoke out and said that one of the people in front of his bench was a menace to society. I'm not letting that guy out, similar to this. I'm not letting him out. This is insane what's going on. It was on the front page of, or it was a story in the Post. I know it was in Daily News and Newsday. They ended up going above his head to the next judge above him, and of course the inmate was, the police prisoner was released. What happened to Dave McAndrews the next day? Nobody ever ran a story about this. Dave McAndrews was taken off the bench in district court and given small claims court. He was punished for speaking his mind. That's insane to me. I don't know why the judges aren't jumping up and down about this, whether they're muted or muffled or their masters' voices are doing whatever. I hear talks about ethics. This is not an ethical problem for judges to stand up and say that the legislature took my job away from me. How does a judge get disciplined for speaking his mind and saying that this is wrong, and they kick him out of district court that he was elected to serve in and put him in small claims court? That's a punishment. Something that needs to be looked into. Lastly, just on my end in the jail, our sheriff retired. We have a new sheriff coming in, from what I understand, a guy from outside. I've heard very good things about him, and I'm hopeful that we can change the mindset here of what's gone on. He's got a big correctional experience. He's got a lot of credentials. He's supposed to be the real thing. I'm hoping that we could do something here. But I know a lot of things are going to wait now until next month when he's brought in. But speaking of discovery, I've had some conversations with the county and the DA's office about this, that inside the correctional facility, crimes happen in the jail. You have all the criminals, well, used to have all the criminals in the jail. They're still committing crimes in the jail. Assaults, weapons charges, stabbings, drugs, all kinds of things, assaulting our correction officers. I have just a handful of officers working in our criminal investigation unit. We are also subject to all these discovery restrictions. So I fought like hell to get a fingerprint machine brought into the Nassau County Jail. We got it. It's together. It's hooked up. They haven't trained anybody in it yet. Surprise, surprise. But so when an inmate assaults an officer, we don't lose the case. In the past, I've talked about it here, where the inmate's in jail, we don't have to run and get it too fast. You know, we'll get them a week, a month or two down the road, and they end up losing track of it, and the guy walks out the door. And a guy that was on my board, one of my delegates, actually went out on 3/4. He blew out 2 discs in his neck fighting with an inmate, and because of speedy trial restrictions, it took so long to charge this inmate, and I've been here before banging on the podium, that they had to drop the charges. This guy's out on a disability, and the inmate walked away with assaulting a correction officer. So now we have this other burdensome thing put on us about discovery. We don't have the wherewithal in the jail. We don't have enough people doing these cases. going inside. I mean, the DA's office is overburdened. The police department doesn't do our internal investigations, aside from when there's an assault and these things are done. They send it over to the 3rd, then they take it over. But attention has to be paid inside the jail, too, because there are crimes committed all the time in the Nassau County Jail. Like I said, assaults, drugs, weapons, we need funding, we need staffing. The funding has to go into this. We just had our budget hearing, and they cut the budget for the Sheriff's Department. I'm still fighting for everything else that goes on. Now we have all of these other discovery programs and stuff that has to be taken care of, and we have less staff. The state legislative proposals that are up there, I'm hopeful that we'll see something productive come out of it. I've spoken to several people, obviously, over the last year in state government. Some, unfortunately, were disingenuous to me and my colleagues as we were speaking to them, that this was never going to go through, even if it was in the budget last year, unless there was judicial discretion. And judicial discretion was specifically carved out of it. So, you know, I have a lot of people that are annoyed with me that I'm speaking about the truth about this stuff, but hopefully we can start turning this stuff around. If it's just cherry-picked, and we'll just put a couple more crimes under bail, and we'll let the judges have some discretion over these other things, that doesn't help. The judges need to have full discretion over what goes in front of them. And if you want to get rid of bail, you know, I don't have any say in that. I think it's absurd that you have to have some sort of a bail system. There has to be some way to assure that people are going to come back to court. We can't just say we're throwing everything out and the system's going to work wonderfully. It's just absurd. There has to be, to me, this whole system should be repealed. Repeal it and start all over again. In New Jersey, they keep talking about how wonderfully it's working in New Jersey. It took them 3 years to phase it in New Jersey. They have judicial discretion in New Jersey. They're you know, now we're talking about going with the federal system. That's it for me. I appreciate the time. If any questions, I'll definitely
Don't
take
leave.
them.
Thank you very much. And you have always been alerting us about this. One quick question, though. I know that you're working with, is it Assemblywoman Martinez or is it Senator?
Senator.
I'm sorry. Okay. Have you discussed with her the possibility of the discovery, you know, to maybe changing that so that, like even Mayor Kennedy said, that if we can have it increase from, like, say, 15 days to 30 days or even 60 days, this will help, you know, all of us.
I have been more on the bail end of it than the discovery, because a lot of the discovery has to do with the police department and the DA's office. But I have been involved in it, and I have spoken my mind about the discovery that has to go on inside my department, because we've had inmates stabbed, drugs, the whole 9 yards, officers assaulted. That all still pertains to us here, and I have had that conversation with them. Up until recently, the main focus, from what I understand, of the people that are trying to rework these laws is that they were going to just focus on bail first and then look at discovery later, until we had that MS-13 murder, and then all of a sudden everybody was going, uh-oh, we got to do something with discovery. So now they went back to work, and allegedly, I mean, not allegedly, there's some sort of a package that's supposed to be coming out. It's under wraps, because I'm sure they're expecting that the left is going to go out of their minds. They don't want anything done with this. It's great to have everybody running free.
Yeah.
But cooler heads have to prevail here, and somebody with a brain has to take over and figure out that this is not working. This is broken, and people are getting hurt. Mr. Maldonado was up here. People have gotten killed over this. How anybody can stand up and say it's fear-mongering and racism is absurd.
I know Newsday wrote that we shouldn't be fear-mongering and whatever. So, but remember, don't let them silence you, because we need people, you know, with courage to speak about this.
The only way they're going to do that is if they hit me over the head with a bat, and I'm expecting that to happen one
All
of
right,
these days.
I'll protect you, but I have Legislator Ferretti who has a couple of questions.
Thank you very much. Exactly. You'll be right on. You'll get a death.
Brian, don't leave yet. I want to thank you for your testimony, and thank you for diving so deep into this. We've hosted meetings, community meetings in bail reform in Levittown, well, actually in Hicksville at Levittown Hall. But the community is very appreciative for your involvement in this, and I'm very appreciative for everything you're doing. I do have two very specific and short questions for you, and it goes back to kind of how we opened this meeting with the minority leader referring to a December 16th, 2019 press conference, which we jointly held.
Right.
Prior to December 16th, 2019, had the administration reached out to you about any type of implementation of this bail reform?
No.
After December 16th, 2019, did the administration come forward with a plan, and if so, when?
There was no plan that I know of. All they did was release inmates because of these bail hearings and whatever else, and whatever was left, I think we discussed it a little bit, people that got out, whatever was left on New Year's Eve, they were let out, and I was there and took note of all the people that were leaving, but there was no plan.
What I'm referring to is the nice bus announcement.
Yes.
Right.
Yeah.
Do you remember an announcement that came after the December 16th?
I thought you meant the Sheriff's Department itself.
No, I'm talking about the administration. Did they come out with a plan after the December 16th, 2019 press conference?
There was a plan.
Okay.
Yeah.
Thank you.
Right. Thank you.
Very much. And now Kevin Black, please. And everyone, thank you all for your patience.
The temptation at this point is to say it's all been said, but I waited this long, so I'm going to say it. The biggest thing about this whole reform package, in my opinion, is judicial discretion. We elect judges who've been sitting in the courts for years, and suddenly they can't make a decision. Thank you very much for moving over. It makes it much easier now. You're all in like central view. I appreciate that. The fact, look, nobody here wants people who are arrested as first-time offenders or for low-level crimes or marijuana crimes to be stuck in jail because they can't come up with the bail. That's not what this is about. This is about serious criminals who are being released because a judge can't take into effect their criminal history, their flight risk, their danger to the victim, witnesses, or the general public at large. This is absurd. How can you not take somebody who's been arrested 15 times for doing street robberies? The judge should be able to look at that and say, you know what, as Judge McAndrew said, this guy is a menace. He needs to go to jail and wait for trial. To have these people just consistently released because according to somebody's definition, it's not a violent crime, it makes no sense at all. And that's probably the biggest thing about this whole reform. There's no common sense in it. Nobody sat back and said, if we do this, what's going to happen? Discovery, the 15 days. You've heard from Jeb Painter, you heard from the commissioner, you heard from Brian. With all the electronic advances we have, to be able to collect this information and put it into a package and have it ready to go in 15 days, when speedy trial requires 90 days for a misdemeanor and 180 days for a felony, what are we talking about? Why does it have to be there in 15 days? Why are we releasing witness and victim information to a defendant's attorney 15 days later? Now, nobody can draw a direct line between what happened to the gentleman in Newcastle who was prepared to testify, but really, would it take a lot of imagination when this was being set up that somewhere down the road something like this might happen, that a witness would be assaulted, much less murdered? I mean, and oh my, how could this happen? You give the information. It's happened. Lastly, well, I just did that. The question came up earlier about did anybody reach out and speak to the commissioner or this or that? And nobody did from the state. But last year, as members of the Police Conference in New York and the New York State Association of PBAs and the Sheriff's Conference, we were all up in Albany when this started to get out. And we were all lobbying against this. And we were all ignored. You know, I understand that you as a county legislature don't get to vote on these things. But, you know, you, just as well as I can call Albany and speak to my state rep, you can do the same. And we should all be doing it. That's all I have.
Thank you very much. You know, to be quite honest with you, and I guess maybe it could be our fault, but we weren't truly aware of the full impact on what was going to happen until we had our budget hearings in, you know, in public safety. And Jeb Painter was the first one to get up and talk about this. And we had inklings, but we never I for one, I'm speaking for myself, I for one never really truly realized the full impact. Nothing was ever sent out by the state what the changes were going to be till he brought it up, and it's been a nightmare ever since.
I think that even the people who expected problems from this didn't expect the level of problems that have become. It's a revolving door. I mean, the commissioner spoke earlier about a guy who robs a bank, walks in, gets printed, walks out. 3 days later, robs the same bank.
Yeah.
I mean, if you work in a bank, you got to be sitting there going, how long is it before this guy comes in with a gun or does something to one of the employees when they're leaving?
I have a woman who contacted me because she doesn't know what to do. She's living in fear. She has this neighbor, you know, that is just very, he's like just being very threatening and, you know, so forth and so forth. And she refuses to call the police because she said, he's going to have my information. He's going to know I'm the person that called him, and I'm afraid he's going to come after me. So this is what's happening. It's like people are afraid now to even report any type of crime, and they're going to have to, like themselves, either put up with it or move away. I don't know what the solution would be. So let's hope that they will be making some changes, and hopefully, I agree with Brian. I think the whole thing should be scrapped and finally bring everybody in, you know, that understands the need for reform and how to best achieve it. You know,
This
so
has
that
gone
it's,
from reform to turning the system upside down,
Right.
favoring the criminal offender.
Yeah.
That's
And
what
put
it's
our
done.
police at a disadvantage. I don't know. But no, first Rose and then you, Delia, okay?
Thank you, Denise, and thank you, Kevin and Brian, and certainly everybody who's spoken, and the other union leaders that are going to speak. But when we were over at Levittown Hall, there happened to be, and I'm going to say a gentleman because he really did turn his life around, all right? There was, well, to me, a young man, but a lot of people are much younger than I am, so
I know
but
the feeling.
he spoke and he said, you know, he goes, I was bad. I was bad. He was drug involved. And he goes, I did a lot of bad things. I did a lot of bad things. And, you know, I was arrested and I was in jail. And all I thought about is getting out of jail. And and whoever made me get into jail, I was out to go get them and whatever. And then he said, and then I ended up doing something really bad. He didn't tell us how it happened, but he goes, you know, I killed somebody. And he spent time in jail but while he was there 7 years in jail, and he did get his life together, and now he does counseling and really tries to help people get on the right track. But as he said, that, you know, the real, I'm going to say bad guys, okay, you know, they're in jail. All they're thinking about is getting out. And he goes, and I'm going to tell you something. He goes, if those discovery laws were like that when I was in jail, he goes, there's not one doubt in my mind that I would have gotten out and killed whoever got me in here in the first place. And, you know, he was very emphatic about it. And, I mean, I mean, it broke your heart to think that he wasted so much of his life, but where he turned his life around. But it made everybody in that room really realize that, you know, this is horrible for so many people. And it worries me that people, you know, women that are attacked, maybe they're not even going to, you know, report that they're attacked because they're afraid to give out their information. They're afraid that now somebody's going to come back. You know, you have somebody in your home who's been attacked or who's been raped, and now that person could possibly be brought back to the home, to the scene of the crime. You know, what if now her husband gets a gun out and kills that guy? Like, now that guy, the husband's in trouble for something that it shouldn't even be happening. It's just, it's such a sad state of affairs that we even have to discuss this. It just doesn't even seem real. When we had our first press conference, I said, you know, if this was a movie script, we would think this is not believable. But yet this is how we're living life today. And it's very, very scary. And, you know, we wouldn't know as much except from the meetings that we've had. Our community, our residents wouldn't know as much if we didn't have those public meetings and get that word out and let, you know, it isn't to spread fear. It's so people know. People have to know what's going on. And, you know, and we do reach out to our state officials and say, what the heck? What are you thinking? You know, they have families. Where are their heads? What if this is your family that's involved? It's just not good.
It's a sad
It's
state of
just a
affairs.
very sad state of affairs. So I'm just going to leave it with that. I don't know if I know other people have something to say, but I just want to thank you for being here today, and thank you for continuing to do everything you can possibly do to keep our residents as safe as they are.
Thank you.
I wanted to say that I think, not being part of this process, obviously, but I think that what you started out with was probably the intention of this bail reform, which is, you know, if someone has a small amount of, I don't know, if someone makes a mistake, you know, and it's a
low-level offense.
low-level offense, and, you know, it can happen. We were all young once the brain doesn't develop, which I really believe now after having kids of my own until you're 25. But anyway, no, they're all good kids. But anyway, I have to think that was the intention. And I do believe that there's no reason that someone should be sitting in jail for so long. And even, I don't know how the other side, but even hearing about how long some of the discovery takes, you know, there has to be adjustments to a few things. But I really think, unfortunately, this was possibly rushed and done quite dramatically, where maybe it should have been implemented slower, and they should have had more input before it went. And I have told our state representatives exactly what I'm saying now. You know, I'm the former wife of a chief of police, and I'm daughter of a criminal judge. You know, and they know that I had no ruling on it, but I've lived the criminal, you know, justice life. You know, I've heard so much about it for years. And I think taking away a judge's discretion is something that, you know, honestly, I really have a problem with as well. Not just because I'm a daughter of one, but I
Must
believe
lead
what
to
you said.
Some interesting dinner conversations.
There's a lot of political, I should say Republican judge. But anyway, so, you know, that's what I'm trying to take from this. You know, maybe there is some good and some positive that can come from this, but it has to be really examined and, in my opinion, scaled back. And the people I'm speaking to in our area, I think, see that now, and that's good. But you know, it's going to be a question of how quickly they can fix it to the point where we can maybe benefit from some of these aspects. You know, so it's happened in a couple of times since I've been an elected official that I've seen like a good intention maybe go wrong. You know, we've seen a couple other instances of that around here also. Something that should be, you know, again, well-intentioned and it would be a good goal to have, but there are other ramifications that happen that we might not have planned for or anything else. So, you know, that's how I personally believe. I agree with much of what I heard today, and I don't think it's going on deaf ears. It's just, unfortunately, you know, there's the way the state works, from what I understand, there's a lot of influences in areas other than Long Island even that might be curtailing this a bit. But I don't think that your discussion or Sully's or anyone else's went in vain. I think that the message is getting across to our local electeds, and I just hope that they can do something to correct it. And so I just wanted to let you know about that.
Thank you.
Thank you, Kevin. Oh, Kevin, you're running away already?
You delay turning that light on. That's what you do.
Just real quick. I mean,
Sure.
Just we're talking a lot about judges' discretion, and rightfully so. That's a key missing part of this law. But just going to something legislator Durgee Witten was just touching on. I'm not going to speculate as to the intent of the legislators who passed this, but their intent aside, in black and white, they passed what they passed. And
Yes,
part
they
of
did.
that, aside from the judge's discretion being taken away, is how they've somehow redefined what a violent crime is. So if their intent was to make this low-level crimes, they failed miserably to do so. I mean, miserably, because this is anything but that. So their intent aside, if somehow they missed the mark of what their intent is, we know that the Senate, New York State Senate, has recently proposed a change to this. They should have absolutely no problem passing that. But from what I've read, there's going to be a problem passing that. So I don't know what the heck their intent was. If their intent was to make this only about low-level crimes, then they really need to get their reading comprehension checked, because that's not what the bill said. And if their intent was something other than that, well, then we have a bigger problem than their reading comprehension. So again, I want to thank you for all the efforts you've done so far and what we're all going to continue to do to work as one voice to get this insanity changed. Thank you.
I would leave you with an old comment. The road to hell is paved with good intentions.
Thank you. James McDermott, please.
Five more breaks. I'm joined at the podium with Kenny Cortez. He's the PBA chairman of the Board of Trustees. And who else do we got? Oh, I got my whole crowd here. I got Frank Arcuri and Brian McQuaid, delegates. I had good morning written down. It's almost good evening, right? But good afternoon. I'd like to thank you for allowing me to speak today on such a very important issue, and I'm sorry if I'm going to be repetitive. I just got to get on record. I'm going to speak to you today not as only the PBA president and a police officer, but also as a Nassau County resident, a lifetime New York resident, a father, a son, a brother, a neighbor, an uncle, and a friend. All of these jobs I take very serious. I'm just going to give you a little history on bail reform from what I know. Criminal justice reform was enacted into law in New York State in the 2019-2020 budget. The reform started January 1st, 2020. It includes no cash bail and no remand for misdemeanors and nonviolent felonies in most cases. Violent felonies, cash bail, and remand can be applied, but the judge must use the least restrictive means. The release on appearance tickets and on certain crimes are now mandatory, not officer's discretion. In crimes such as resisting arrest, the subject has to be released on an appearance ticket. My members will be required to issue appearance tickets for all petty offenses, misdemeanors, and most Class E felonies, unless the following circumstances exist. The arrestee has one or more warrants, or he has failed to appear in court in the last 2 years, or he is unable to or unwilling to verify his identity, or in certain domestic cases, or if the victim is seeking an order of protection against the subject, or if the crime that involved possibly having the defendant's license suspended or revoked, or if the subject poses a danger to himself mentally or medically. And this is very important. I know we've spoke about this over and over again, but pretrial discovery evidence. This new law places an unreasonable burden to turn over all evidence to the defendant within 15 days, including names and contact information of victims and witnesses. From what I understand, the reform was enacted because the legislature felt that there was systemic inequity of who are held for trial. They felt that people with money were freed, and the poorer subjects who committed the same crimes were remanded because they didn't have the means. Discovery changes were made because they felt the defendant was not giving all the information in order to defend himself or take a proper plea. Issues we feel we need to address in the bail reform are judges' discretion to remand, defendants getting released and committing the same crimes over and over again, subjects being released that may pose a danger to others, all subjects being treated similar. People are different, and releasing them into general population should not be a cookie-cutter approach. Some defendants, not all, are just flat-out danger to society. We need to add more crimes that to this list. And finally, give judges discretion in all cases. Issues that we need to address in the discovery laws. Currently, all evidence must be handed over and defended, like I said, in 15 days after arraignment. That has to change. It's just not enough time. This includes victims and witnesses' identities and contact information. Prior to this, defendants only got that info prior to trial. The new system is causing witnesses to hesitate to get involved and possibly put the witnesses and the victims in further fear of their safety. This system is placing criminals' cases in jeopardy, and the prosecutors cannot turn over the evidence on time. What we see as some of the solutions are give the evidence to the defendant as soon as reasonably possible and on a staggered basis. Evidence immediately in the district attorney's hands can be given over. Test results such as blood evidence, DNA, and et cetera should have a reasonable time frame so that the test results are done properly, not hurriedly, in order to have a proper case against the defendant as well as protect his or her rights for a fair trial. However, victims' and witnesses' identity should not be released unless absolutely necessary. And the burden should be on the defendant to prove why he needs this information before a trial or a plea bargain. Cases should not be put in jeopardy just because of time restraints. I ask all of you, both sides, I see both sides of the aisle, to have your voices heard in Albany. You're our voice. I got to know, all of you. You're all good people on both sides. You know this is wrong. You know this has to be reformed, and it has to be reformed now. Remember, it's never too late to do the right thing. Thank you.
Thank you very much. And, I know that Jeb talked about the morale with the ADAs in regard to this. Do you feel that this is having an impact on the morale of your offices?
Oh, of course. It's turnstile justice. You're at New York City. It takes a little bit longer to book somebody, and going to Central. I was a New York City cop in Brooklyn 32 and a half years ago, but just the sheer numbers alone in there, you're the guy's out on the street before you're finishing the paperwork, and that's what am I doing? What are we doing here? It's definitely has a negative effect. But our guys are professional and girls, and they're doing whatever they have to do. So we're doing what we have to do. And this is our plea to have Albany listen to you. And I heard Kavan say that let's put a letter together. Let's put a letter together. Whatever you guys have to do together, and let's get this thing done right. Thank you. Anybody else?
I think that's it. Thank you so much.
Great.
And we
Thank
will
you
do
so
the
much.
letter. No, keep it up. I really,
Thank you.
your advocacy. All right. Okay. Let me get my next. Oh, I can't get to change my glasses. Joel Burrs, please. No, no. Is he here? Oh, I didn't realize. Okay.
Sorry about that, but my blood sugar seems to be dropping. And being here this long since this started is...
No need to apologize. You have a lot of patience, and thank you for waiting so long.
Well, from when I originally wrote here, it said good morning, so now good afternoon, legislators. I'm used to being an extemporaneous speaker in this type of an element, but because of the gravity of this and the people that I've spoken to with it, I've made a prepared statement that may repeat some of what's been said, but it also should, thank you. It should also help people maybe realize that it's not just the ones who are working in the police department or the sheriff's department or the DA's office. Also the people out in the streets, in the neighborhoods, the ones who live in Nassau County know what we're talking about. So let me get on with my statement instead of babbling there. My name is Joel Burse. I am the immediate past president of the Northwest Civic Association of Hicksville, also immediate past president of the Hicksville Community Council. During my career, I have been a member of the Chambers of Commerce in Hicksville, Levittown, Wantaw, Farmingdale, East Meadow, Lindenhurst, and the Long Island Association. I currently serve as an appointed member of both the Nassau County Bus Transit Committee and the Police Commissioners Community Council. I hold memberships in the Nassau County Police Reserves Association and the New York State Fraternal Order of Police. In my youth, I served as an auxiliary police officer in the Jericho unit. I made this introduction to demonstrate that I believe myself to have an accurate feel for the pulse of my fellow county residents with regards to many matters, especially the bail reform laws implemented by our state officials this year. There are also concerns regarding our police being able to remain as effective as they always have been. There we go. Last September, Senator Anna Kaplan came to introduce herself to Hicksville at our Northwest Civic Association meeting. At that meeting, she spoke of all the wonderful items she voted for during her first few months in office. However, she omitted these new bail reform laws from her accomplishments. In October, our POP officers from the 2nd Precinct came to the next meeting we held to inform the community about the upcoming changes to our criminal justice system in 2020. It was really a show of horror and shock that people didn't know what was coming. The very next morning, I appeared before the Oyster Bay Town Board and implored them to communicate with state officials that their constituents were seriously concerned about quality of life issues with these changes. Assemblyman Mike Montesano spoke at our November meeting and brought with him the list of offenses that no longer would require posting bail. One that sticks out in my mind was for carrying a gun on school grounds. He also spoke of the new discovery portion of the law that effectively gives more rights to the suspect than the victims. Main points being disclosure of personal information and visiting the scene of the crime even if it's inside of the victim's home. It is public knowledge that immediately after being arrested and released, several individuals committed additional crimes. Often suspects are released before their arrest paperwork is completed. A cop off the street for making an arrest is terrific, but the cop still off the street performing the associated duties to the arrest while the alleged perpetrator is back on the street committing additional offenses is horrific. Therefore, it is incumbent on all elected officials at any level within New York State to insist that these laws be revisited, revoked, or revised for the safety of the residents in their constituency. I now challenge all of you in our legislature to act accordingly for the quality of life in Nassau County. A lot of you have a pipeline to these people that created the situation, and I hope you do speak to them loudly and clearly, because it does sound like the legislature is in tune and is on our side to try and cure this problem. Thank you.
Thank you very much for your comments, sir. It really is important to hear, especially with your background, and you're spurring us on to make sure that we get to that state and make these changes.
Have a good day.
Okay. All right. Jeff,
just make sure you have something to eat.
Yep. Oh, you gave him, okay, all right. I'm sorry. Jeffrey Gross, Detectives Union, and I'm sorry, my eyesight is, even with glasses, and it's not that good, so I apologize.
No apology necessary. It's Jeffrey Gross. I represent the detectives of Nassau County. I want to thank you guys for having the hearing today, and I want to thank all the prior speakers. I wrote about 11 pages of notes. I don't like to reiterate what's already been said, so I've been crossing it out here and there. I am one of the representatives who goes to Albany almost every day that they're in session. I'm up there with Ed Perkins from the PBA and Pete Patterson from the, the PBA and Eddie Perkins from the SOA. But we deal with this bail reform, and we've been talking about it for since March or April of last year when we knew it was coming down the pike, as has been explained to you already. I don't think any of us knew how bad it was going to be. But I do have to say that when you tuck it into the budget and you don't allow people to vote on it as a standalone and you don't allow it to mature on its own, that's when we have these problems. And I think that was done on a political, even though we don't want to keep this political or say it's political just by them doing that. It wasn't a natural progression of the law or the changes. The laws change every year. Every year new bills come in, they're addressed, they're appealed, and that's how it goes. You don't change the entire landscape of the criminal justice system in one sweep where you hold people, really, as Brian said earlier, to a gun to their head. New legislators up in Albany didn't know that they could vote no on the budget. They felt that they had to do that for their constituents to keep it going. I spoke to many of them up in Albany, and that's how something like this was able to exist. It's also something that you're likely to see, and I don't have any firsthand knowledge, that that's how they're going to roll out the marijuana bill. They're going to put it in the bill, in the budget, and they're going to roll it out. And those ramifications, we're going to spend a long time figuring it out. But as much as you may be able to fix bail reform by judicial discretion and review, those seem to be easy fixes. I think the bigger problem we have is discussed by the ADA before, is the discovery reform. This discovery reform, it's not as much as like we let the guy go and now the detectives have to go out and find the guy because he's got a warrant, and that's a big issue for us. But with the discovery, you're talking about dismissing a case where there was a victim, and it could be a serious case or whatever, and you're going to dismiss the case. The guy, it's not that we have to go get the guy. It's going to be dismissed, and he's going to leave. And what I want to point out is you have this 15-day discovery that they mandated, but yet when we send out subpoenas as being a detective for phone records or bank records or whatever, we allow those entities 30 days to comply with the subpoena. So if I'm sending phone records out and I'm allowing AT&T or Verizon to give me 30 days to get it back, how am I supposed to keep up with the speediness of trial, which is already 15 days? It already is set up to fail right from the beginning. They didn't change any of that. So anyway, it's a huge issue. I don't want to reiterate and waste your time, but I will say that how can they say that they can't trust the judge on the amount of bail or the seriousness of the crime or the history of the defendant when we trust him later on to make the sentencing? It's the same judges. So you don't trust them on bail, but in the end you're going to trust the same men. It doesn't make sense, and a lot of it is just trusting in our system the way it's always been. Anytime you have sweeping reforms that now are going to take us years to fix is not a good thing. But thank you for your time.
And thank you very much for your patience. And let's hope that the state legislature has learned their lesson. And we will send a letter and also to remind them, don't make the same mistake twice, with the marijuana legislation. Take it out and vote on it independently. But what really bothers me most about all of this is that they were aware of some of the impact, the negative impact this was going to have on our in law and order here in New York State. Even when you listen to that interview with Senator Kaminsky in Power and Politics, I think on News 12 or whatever, and he admitted that he met with people in law enforcement and DAs prior to his voting on this, and he still voted for it, even though they told him, please don't. So I think that all of them, they may, they may say, well, we shouldn't have, but I really wish that some of them who are more seasoned should have showed some restraint and to put the halts on this so that we wouldn't be going through this at this point. But I thank you very much, because I know it undermines our detectives as well. We're trying to give you support.
I agree, and it's very frustrating for our detectives, our police officers who work on these cases. They're important to us, and then they're not even going to be able to get into court. They're likely to get dismissed beforehand. Right. And, I have to say, for our own district attorney, Madeline Singh has ran up to Albany from the beginning, and she recognized this, and she brought it to the governor's attention, and he told her, in some sense, whatever, not to quote it, but he said that that I don't think you fully understand what the legislation is. And she said, no, I do. And she was right. She knew it was going to be a problem. She addressed it. She went up to Albany. She's continued to go up in Albany as an advocate for you know, we're not against change, but we don't want change just to have change. It's got to be commonsensical. It's got to go with the normal evolution of the legislative process. You can't just roll something out where it changes everything, where it costs, you know, these small municipalities millions of dollars. Yeah. And we haven't seen the problem. And as ADA Painter said before, if you wait until July or August, that's when all the bottom is going to fall out on a lot of these cases, when they're going to be held to task and they're going to have to let these cases go.
Exactly.
And, you know, I heard this story, if you mind for 2 seconds. New York City woman, elderly woman, she had $30-something thousand stolen from her home care aide. She went to the police. She called the police. They made the arrest. The DA refuses to prosecute the case because they have to get the bank records, which they know is going to take over 30 days. They can't do the 15 days. And the problem with that is the woman's not able to get the order of protection. So she's not able to prevent the home care aide to come to her house and beg her not to press charges that she'll pay back and harass the woman because it's not an active case. So they won't give the order of protection. So now the DA there is waiting for these bank records to come back so they can start the clock. I don't think that's the intent of the law, where we're always going to be doing this stuff, and we can't protect our citizens. We say it's for public safety, but you can't give this elderly woman in her 80s an order of protection until the bank records come back. And the banks aren't held to the 15-day discovery rule. You know, they're held, when they get the subpoena from the Nassau County judge, it says you have 30 days to comply. That's the minimum. So how can we possibly go in 15?
Exactly. And I think to myself now, if like with DA Singas being on that justice panel, you know, if all of those people were first brought into the room to come up with a model of changing the justice reform system to make it more, make it fair for some of the people who really shouldn't be in jail, what a different story we'd be telling today, you know, rather than trying to.
I agree. We don't want one single person in jail more than they have to be.
Right.
Or an innocent person.
Yeah.
We don't want that
Exactly.
even one time. But we're paying for it by having tens of thousands of cases that are going to be thrown out because we wanted to protect that one person from being in jail. And I get it. Yeah. It's got to work itself out. This way is not going to work. And you know what? The problem is when the bottom falls out in July and August, the legislators are not going to be up in Albany. They're going to be on break. Yeah. And there's no way they're going to address it. They don't come back usually until January of the following year.
They'll be campaigning.
Correct. They'll be campaigning. So it'll be a very interesting fall.
Interesting, yeah. But try to be safe, please.
Thank you very much for your time.
All right, Pete Gaffney? He left, okay. Susan Gottler? She might have left. Yeah. You don't see Susan, right? Okay, I'm going to say this one. Michelle Esquenazi? Ron Rochester? Good afternoon, sir. Thanks for your patience.
You're welcome. My name is Ron Rochester. I am a retired federal agent. I was a criminal investigator for over 25 years. In addition to that, I had collateral duties as an undercover agent, a tech agent, which was body cameras and GPSs and pole cameras, such like that. And I was the field office two-way radio communications officer. And I came in, I've been discussing this with my community and people around my community for some time regarding the bail reform, and I won't go over a lot of the other things that people are going over with, but the discovery issue that is really an important and a very, I want to call it, I find it to be very, the word for it, but anyway, I find a problem with that issue. One of the things which have not been discussed, and I think that people are missing the issue is, we have a lot of undercover agents, we have confidential informants, I mean, we talk about witnesses, but that information that is going to be disclosed to defendants and defendants' attorneys, you're going to put the lives of undercover agents at risk. I spent many years as an undercover agent, and for my information to get out there, and for someone to not have maybe my home information, my family's at risk, something like that, it's really troubling. The fact of the matter, what hasn't been discussed, is that there is a tremendous amount of task forces that have federal, state, and local agencies working together. Now you have that their information that has to be discovered. You're going to have to go to these federal agencies, nobody's discussed that, and get information from them that have to be disclosed to defendants in certain cases that may be put on a state level. You're going to have undercovers who their information may be disclosed, and they may be working on a federal case. And now what? And what happens? Now you've got a problem with a big federal case that's out there because they're working on that case with federal agents. This has got wide-ranging ramifications that people haven't even discussed yet, and how it's going to work. And when you go to, like the radio system, New York, you have the county has a radio system, all that's recorded. On many federal agencies, they do not record the radio information. Defense is going to ask for that in discovery. You know what? If they can't provide it, that case will probably get thrown out. These are all things that should have been discussed and thought about well before this ever been put into effect. It's wide-ranging, and this is really, really important. And now we're going to try to backtrack and try to fix this, and I have a real problem with that. And I think we really need to talk to our legislators, people in Albany, to say, hey, you need to look at this in complete detail. You can't, give a whitewash this thing. It goes well beyond what a lot of people are talking about now, and we need to make sure that we put something in place that is not going to come back and shoot us in the foot. And it's really important that people look at all. We need to bring in some of the federal AUSAs and involved in this and say, how is that going to affect our joint task force and our joint investigations with this law? Nobody's looked at that. So, and that's the reason I'm here. I thought it was important for me to stay and discuss that and make everybody aware that this is something that we need to look at.
Thank you for your patience, and you actually brought up some issues that we never even thought about, like, whether or not, what impact it does have with CIs and undercover.
I've been on the other side of this as a federal
Yeah.
agent, so I know what we're talking about. I've had many state undercovers. I've worked on city and state investigations myself, and I've had guys work with me on federal investigations, and they do cross.
Wow. It's frightening.
It's very frightening.
We
It's
don't
very
really,
frightening.
wow. Well, we're hoping that the state will finally listen to the residents and say, we need to backpedal on this and make some changes to protect all of us.
Thank you.
And thank you very much. I really appreciate your comments. Okay. I know. Manmahan Kara, K-A-U-R? Okay. That was our final slip, and I thank everybody. Okay, you can end it. Okay. Steve will close up our meeting. All right, thank you.
Oh, thanks. I just wanted to thank everyone that took the time to appear today, everyone that may have been watching at home. And I want to thank everybody for their comments. I think there was a lot of information that was provided today. There was a lot of insight that people provided, particularly in our law enforcement community, our community members who spoke about the practical impacts of cashless bail and of criminal justice reform. I've got to say, though, government has no more important responsibility than to protect the safety of the public. And from where I sit, at least, I think that this has been a complete failure of New York State government to do that. And I know a lot of people got up today to kindly offer a pass to the state legislature as to why these reforms came into place. The simple fact of the matter is we heard from many of our police unions that were up in Albany prior to this bill being passed, alerting state legislators to the fact that there would be consequences and that there would be problems if criminal justice reform and cashless bail was passed. The problem is that they didn't hear, is not that they did not hear what would take place. The problem is that it seems as though they did not care, and they simply passed it anyway. I had a conversation with my own state senator at a public meeting who explained, well, it was passed at the last minute as part of the budget, and I didn't even know that it was in there. Honestly, not an excuse. If you're complaining about the process, you control the process. Marijuana legislation that they're talking about being passed as part of the budget this year. It was supposed to be passed as part of the budget last year, but it wasn't. Why wasn't it passed as part of the budget last year? It wasn't passed as part of the budget last year because legislators in Albany got together and removed it from the state budget. So the notion and the concept that maybe freshman legislators didn't understand, maybe the folks that are supposed to be representing us in the state Senate up from Nassau County up in Albany didn't know that they didn't have to vote for the budget. That is absolute nonsense. And the thing that frustrates me most about this is that, yes, this may have started off with great intentions, trying to make sure that a low-level criminal, a first offender, wasn't going to sit in jail because they couldn't afford to pay bail. You look at the list of crimes: burglary of a residence, using a child to commit a controlled substance crime, injecting another person with a controlled substance, manslaughter, possessing a weapon on school grounds, solicitation of a minor for prostitution, assault as a hate crime. These are not low-level criminal offenses, and they're in black and white. Everyone had the opportunity to see them, and it was ignored. And Mr. Maldonado, who testified earlier today and was our first witness, he's the one that's paying the brunt. He's the one that's suffering the consequences, and his family and his son, who will never come back because our state legislators didn't take the opportunity to listen to what was being said. And what has to happen here, and I hope we do send that letter up to Albany. I know I've reached out to my local legislator on multiple occasions to share my thoughts. I hope we do send that letter. But what needs to happen here is not tinkering around the edges. What needs to happen here is a complete repeal of this legislation, and then we can sit down and have a bipartisan conversation with law enforcement, with the ACLU, to talk about sensible criminal justice reform that actually accomplishes what we think the good intentions of this legislation started out to be. That is not what's happening today. And every day that we delay it is another day when there's a chance that there may be another family, just like Victor Maldonado and Jonathan Maldonado, his son, that there'll be another family like that, the victim of MS-13 in Newcastle, or any of the countless examples that are in our papers every single day. They're the ones that are being put at risk, and they continue to be put at risk every day that we delay this. And my fear is that even though the legislators that we have here in Nassau County are now saying we want to walk this back, there are elements up in Albany, including the leadership, I think, in the State Assembly specifically, doesn't, New York City people. And that does not want to walk it back. And that's the problem with doing something and thinking that you're going to be able to fix it later, is because you have to get the votes to be able to fix it, and you might not. So the only way that that's going to happen is through hearings such as this, through conversations that we're having in our own districts, and from each and every person that's listening to this today, reaching out to their state legislators and letting them know that the failure to act is going to bring pain. Whether that turns out to be at the ballot box, whether it turns out to be in public meetings, whatever that turns out to be, action's not going to happen until they realize that there are consequences. And so, I appreciate everybody being here today and sharing their thoughts, but the message to take away from this today is that there are a lot of issues that are created by cashless bail and criminal justice reform, and that we need to stand up and we need to speak out together to make sure that the right action is taken up in Albany to protect public safety.
Thank you very
Thank you.
much. Very eloquent.